Disc 7, Part 1 of 2. Confessions from a Psychotic Court. Starring Justice Judith ENSOR in Fraudulent Judgments and Payment Scams. Follow Trail to Delusion or Trolley.
Confessions of a Psychotic Circuit Court Judge via Fraudulent Judgments and Payment Scams. Working Development Research Stage. Agreement. Pause to read. Minimum age of 18 required.
Rights? Hell no.
What about our rights? What about our rights?
Be quiet. Shush.
Justice. A judge abides by facts, laws, truths and evidence. A justice creates their own facts, laws and truths, in the face of opposing evidence, and, or knowingly applies, lies to law. When the scales of justice become the scales of injustice. Note, this ad has been authorized by the actions of the Judgetess. Judgetess Judith ENSOR. Note, the knighting of a justice is taken very seriously. Similar to the Supreme Court, it's for life. Important, this term was specifically designed to separate the honorable judges from the dishonorable ones.
Judicial rules state a judge has 60 days to render a decision. However, nearly 10 months later, and on September the 18th, 2013, Decision Day, pages 193 to 197. Judge Judith ENSOR completes another goal set very early on. Mr. Stengel is the problem. And he must pay, and pay. Judge Judith ENSOR provides her evidence, confirming her positions and allegations. Which is where we start. It begins at the bottom of page number 193. Before we move forward, in regards to Mr. Stengel's research, and these very research subjects, there are many things you need to know about these personality types, aka, unconscionables. However, just a couple things, for now. 1. Allegations equals confessions. 2. They contradict themselves. 3. They are always the victims. 4. It's always someone else's fault. 5. There is never any actual evidence. Therefore, they must. 6. Redirect focus. Then. Attack. 7. They never take responsibility, or admit wrong. 8. They are legends in their own minds, often wanting to talk about how great they are. 9. They are by default pathological liars. 10. The extremes tactic. Notes regarding number 1. Allegations equals confessions. The psychology field calls this projection. However, allegations equals confessions has many more advantages, which you will learn later in the presentation. Number 6 will often act as number 7a as well. Number 7, they admit to no wrong, therefore won't apologize unless they want something. Number 10, not hot or cold, rather frozen and on fire. This is explained later in the presentation. September the 18th, 2013. Decisions being made are 1. Mr. Stengel's motion to remove Leon W. Berg as best interest attorney. Note, ENSOR intentionally held this motion since May. 4 months. 2. Merits, divorce. Note, divorce. The transportation vehicle they all drive their frauds using. 3. Contempt hearing. Buckle up. Transcript, September the 18th, 2013.
This is one of those tricky things, and perhaps someone else will see it differently, but I am telling you, Mr. Stengel keeps coming up with money. Now, I can't tell you exactly where it is. I really can't. I can't point to an exhibit that says exactly where it is.
Mr. Stengel has money. However, she can't tell you where, or point to anything. But she is sure it's there. This is how she came up with her ruling on who has money to pay, and pay. This is how trapped she is in all of her own frauds. Trapped in Mr. Stengel's meticulous documentation of all of their crimes, spanning years. So trapped, she, like them all, must publicly state and swear 2 + 2 = anything but 4. And must do so forever. Can't point to any, unlike Miss Sileski's multiple false zero-income filings, and sworn testimony, and countless bank statements, proving she has money, and loads of it, all the while repeatedly lying about it, along with everything else. Besides,
this is one of those tricky things.
Is this a magic show, or a court of law? Allegations equals confessions. Don't worry, Mr. Stengel will expose how all the tricks are done. The same exact day, on pages number 16-17.
Mr. Rudo, I already know that Ms. Stengel hasn't always been honest. I know that. I know she lied to the police officer because she had Mr. Stengel's phone when she said she didn't. So I know that. And it didn't escape my notice that there were several discrepancies in the financial statements. In fact, in that hearing we had, that lasted several days, it was like every day. Actually, I would get a before lunch and after lunch amendment. So, I mean...
A manufactured, virtual world, containing pure delusion. What do we really have here? A confession. Like Mr. Bradford G. Y. Carney, so too, did Judge Judith ENSOR, just kept coming up, empty. As he manufactured his virtual world, containing pure delusion. November the 30th, 2012. Last day of trial, and one of Mr. Carney's closing arguments.
As the court pointed out earlier, it's a whole lot more expensive to lie than it is to tell the truth. Because as Mr. Fetter said, to ferret out the lie, you've got to do more work. And the more work I did, the more frustrating it became because I just kept coming up empty.
Yet his own expert swears under oath.
And as a consequence of your review of those bills, do you have an opinion within a reasonable degree of professional legal certainty as to whether or not they were fair, reasonable, and necessary? I believe they were fair, reasonable, and necessary.
This is all happening in front of Judge Judith ENSOR, who herself confesses Miss Silisky is a liar, and provides false financials, repeatedly. Mr. Bradford Carney confesses his $200,000 of bills resulted in him continually coming up empty. Yet continued, without being paid by Miss Silisky. At what point does the work become unreasonable? As did Mr. Leon W. Berg, as he manufactured his virtual world, containing pure delusion, the same exact day, on page number 37.
Contrary to what Mr. Rudo said, very little of my perspective on this case had much to do with what Ms. Silisky said, or didn't say, or did, or didn't.
Huh? Yet billed in excess of $62,000, and states he relied on his expert, Dr. Killeen. Except the best interest attorney rules state he is to do independent investigations, and stated in his own contract. Also, Dr. Killeen, although false, stated she completed her investigations in September 2011. What was Mr. Berg doing 48 months prior? And if that were the case, what was the need for Mr. Berg? That takes care of the virtual world, and the few samples of the over 2,000 documented false statements to the court, and fraud upon the court. As we enter reality, the true reason, never mentioned by Mr. Berg or Dr. Killeen, was provided to Mr. Leon W. Berg, upon his own request for information, way back in January 2011, and received, this, weeks later in February 2011.
Dr. Alan Kimmel, Ms. Stegel's medical doctor, aware of Ms. Stegel's mental health issues.
Yet Mr. Berg and Dr. Killeen refused to obtain those medical records, or make any mention of it at any time, in any form, ever. It also went to Mr. Carney, as well. How else could they all manufacture their fraudulent bills? Mentally ill equals lots of bills. Yet they all, with foreknowledge, falsely state it's Mr. Stengel that has mental illness, including Judge ENSOR. Yet they all collectively ignored all facts and realities.
Dr. Alan Kimmel, Ms. Stegel's medical doctor, aware of Ms. Stegel's mental health issues.
It's August 26 at 9 a.m. and if anyone hears this, I just want to stay with my dad. By that I mean like full custody with my dad.
And Dr. Catherine Killeen, as she manufactured her virtual world, containing pure delusion, but confessed to it, on December the 1st, 2011, on pages 54 to 55. Also included, Judge Kathleen G. Cox, can't point to one, either, as she manufactured her virtual world, containing pure delusion. FYI, November the 16th, 2015, is when this crime ring's temporary gag order was heard. What would be their fifth time, over the 5+ years. This, in order to remove Mr. Stengel's First Amendment rights to free speech. Their desperation is simply to prevent Mr. Stengel from informing their hundreds of victims they are in fact not their friends, protectors, or any witness, as they were all conned and manipulated to believe, rather their victims and pawns in their psychotic games. At times, you will hear Mr. Bradford G. Y. Carney's stress breaths. These are simply implosions caused by what these personality types, extremely high-level unconscionables, fear most: reality.
These actions are against me. They put me in prison for this fraud. Okay? And I have the right to show how this all occurred. And this is after that. So I can't start it at the prison thing, because what would that show? Nothing. That wouldn't be anything. So I have to show, like, how did this come to be? And where are my First Amendment rights to say what's so? And they have yet to point to anything that's false. Okay? All they're doing is alienating people.
They point to several things that are false.
Like what?
There are all kinds of things in there that are false, Mr. Stengel.
Like what? Please tell me one.
I'm not going to get into this debate.
But there isn't any. I haven't provided any false information whatsoever.
Judge Kathleen Cox did not provide even the one Mr. Stengel asked for, other than general, roundabout, redirected nonsense, as you heard.
I'm going to live with the letter of the law. I'm going to live with the letter of the law. I'm going to live with the letter of the law. I'm going to live with the letter of the law.
Like your personality partner, Judith ENSOR, refusing Mr. Stengel, even questioned Mr. Carney regarding his $200,000 of fraud bills. Follow it when it suits you. Otherwise, screw that. Correct? In case you were out that day from law school, that's not following the law, rather, using the law. The difference is, one is honorable, and the other is criminal.
I'm not going to get into this debate. I'm not going to get into this debate. I'm not going to get into this debate.
Knowingly, with full knowledge and malice, falsely accuses Mr. Stengel of lying. Mr. Stengel calls her on her own lie. Her response is, she is not going to debate it. There is nothing to debate. Just provide your evidence.
Rule 2.7. Responsibility to decide. A judge shall hear and decide matters assigned to the judge, unless recusal is appropriate.
Miss Silisky provides no evidence of any allegations or claims, besides her own manufactured virtual world, containing pure delusion. And, although these samples are extremely psychotic in nature, individually, add to that, they all agree.
But he looked me in the eye the day before you got in this case, Mr. Bruto, the day before, and said, I don't have any money. Next day, there you are. I don't know. I don't know where it's coming from, but the man has access to funds. And frankly, he has access to funds now based on my decisions with respect to these buildings and not being marital property.
And I can tell you the check that we got, Your Honor, was not from Mr. Stengel.
All right.
I recall.
Besides, what's the difference whether Mr. Stengel has money or not? If he has $50 million, he is still not responsible for your crime ring's designed fraud from day one. You steal his children, feed them to a medically documented mentally ill, violent, crazy nut job, rape them of their childhoods, knowingly con and involve their schools and entire communities in your frauds, and Mr. Stengel should pay. Really? When Alex said and documented in his audio journals, often being beaten up, and he wanted to live with his father 100% of the time, and Maya with her mother, only every other weekend. Yet not one mentioned by Mr. Berg or Dr. Killeen. Known as white-collar child trafficking. Mr. Berg and Dr. Killeen, even obstructing justice, by manipulating Boyce Latin School of Maryland to not report Alex's reported abuses to his school, to the authorities. Twice. Let's listen to Mr. Stengel explain it to the personality person you handed all of this fraud off to, after you were warned by the Commission on Judicial Disabilities, directly related to Mr. Stengel's cases, and recused from Mr. Stengel's cases. Someone you were sure would not report your actions. Someone that will also keep this fraud case specially assigned. Translated, alienated. Surely the Commission would not allow any judge to call someone a liar without evidence. Would they? Otherwise, actions like that would still be considered honorable. In which case, the Commission's rules are in place to protect the corrupt judges, not the public. We will take a 16-minute detour into the future. We call this reality. It will be informative, educational, and also see how some of their tricks are done.
Mr. Carney manufactures bills. He calls people, he harasses them, and then he bills for it. Okay, and then he gets these people against me in my divorce case, and then winds up having them sign these things against me for criminal prosecution and stuff. It's complete insanity. I mean, it's just insanity, and I don't know how else to define insanity. I mean, you can't commit a crime, which is what they do. He's got $200,000 of fraud bills in a case where he didn't even get his client, not for one day, was above water in her payments, not even for a day. There's a prenuptial agreement where she gets nothing. How many attorneys are letting their clients go for up to $200,000 in legal bills without this fraud thing going on underneath? Because Mr. Carney knew that the whole thing was a scam. I had a prenuptial agreement, she wasn't getting anything. Why is he representing somebody who falsely claims she had zero income? Mr. Carney suborns all this garbage, okay? And so they're the ones committing crimes. All I'm doing is defending my name and trying to protect my kids. That's all I've been doing for years. That's it. Now they put me in jail, okay? Now I'm going to show the road to prison. Now I'm going to show the road to prison. Now I'm going to show the road to prison. Okay? This is how we got here. It started off with Miss Selesky in your courtroom committing an insane amount of lies and fraudulent testimony, just bizarre stuff. Okay? And it has not stopped. And if you ask Mr. Carney or any of them, they all seem to have the same wrong answers. None of them ever seem to have, they have ever, 2 and 2 equals anything before. And collectively, okay, so I have documented meticulously their crimes. They're trapped in the documentation, Your Honor. That's the problem. Because it relates to my First Amendment right to show that I have a right to show how I was wrongfully incarcerated. And I have the right to show the road to that. You can't take this out in a vacuum. You just can't. I mean, this has been going on for 5 years. I've yet to lie in court. Okay, I have not been dishonest or deceitful at all, and that's all they've done. I have over 2,000 counts documented of perjury, subordination of perjury, fraudulent statements, misleading. This is all just in the transcripts alone and in the filings. This has nothing to do with emails or anything else. If you count them all, there's over 4,000. Trust me, Your Honor, this case is a landmark case because there's nothing been documented like it. And what happened was technology just happened to catch up to these people. That's what happened. Okay? And they screwed with my kids. They used my kids as Mr. Carney's own ATM machine.
How do all the thugs all come up with the same wrong answers, time and time again, for years? Let's let these 2 thugs demonstrate how it is done, as demonstrated on November the 16th, 2015. This is in real time and timeline order. Then you will better understand exactly what Judith ENSOR is doing.
Mr. Stengel, do you have access to your email in the building here today?
Which email account?
Whatever one was sent to. Any email account, if you have access to.
I have access to the email account, yeah, but I don't know which one they sent it to.
Which one was it sent to, Mr. Klein?
It was sent to markstengel12@gmail.com. Well, I've never had that email.
Note, these are in the timeline order.
I used to use markstengel2@gmail.com. I never had markstengel12.
Note, let's listen again. I used to use markstengel2.
I used to use markstengel2@gmail.com. I never had markstengel12.
Mr. Stengel repeats that.
I used to use markstengel2.
Note, if you are counting, that's twice. Mr. Stengel said markstengel2 is an account he used to use.
I can just look at his, I mean, for times, I can just look at his and then I'll give him back to him.
All right. There are extensive exhibits that include screenshots, printouts, copies of tapes, The main portion of this is the motion, because you're either familiar with these materials or you're not.
The email address I have for Mr. Stengel, I was misreading the L in his last name for a 1 in front of the 2. It's really markstengel2@gmail.com, which is Mr. Stengel, he admittedly just said to the court, that's his proper email address.
Huh? Really? Let's rewind.
See, I used to use markstengel2@gmail.com, but I never had markstengel12.
Mr. Stengel repeats that.
I used to use markstengel2.
Furthermore, how would Mr. Stengel even know to be here today, Judge? It's my understanding without success that he didn't speak to anybody.
Note, how would Mr. Carney know who or if Mr. Stengel spoke to anyone?
I don't know.
But I also have, and I wanted for the record to reflect, attached a copy of it, I think, to the court's copy. I sent a letter to Mr. Stengel on the 12th, which is Thursday of last week. Dear Mr. Stengel, as I advised you in the 2 messages which I left, and I will represent to the court, as an officer of the court,
Sit down for this next one.
that email did not come back to me, did not bounce back to me for all intents and purposes. We have no reason to believe
What you sent it to was markstengel2@gmail.com. That's what Mr. Stengel confirmed was his email address.
Huh?
This is an old email. I haven't used that in quite a long time, Your Honor.
Let's re-listen to Judge this Kathleen G. Cox.
that email did not come back to me, did not bounce back to me for all intents and purposes. We have no reason to believe
What you sent it to was markstengel2@gmail.com. That's what Mr. Stengel confirmed was his email address.
That email flow you just experienced, in real time and in timeline order, began prior to the break. Then following that short recess, Mr. Carney immediately created his own delusional and virtual world, as Judge this Kathleen Cox happily frolicked along. FYI, even after the 3rd time Mr. Stengel clarified he hasn't used it in quite a while, Mr. Carney continued emailing that email address, as seen in his documents. Besides, Cox's chambers called Mr. Stengel a personal invite to their lynching. Anyway, that's how all their magic happens. They just make the shit up. Then even after correcting them multiple times, they continue with their designed delusional and virtual world. Important note, in Mr. Stengel's research, it's not so much that they make it all up, rather, they do it right in front of the source, showing the level and depths of psychosis in these research subjects. This is seen many times by Miss Siliski in many of the videos taken inside the home. It's quite remarkable to watch. It's not an occurrence, as one would think, such as, oh, they lied about something. Rather, it's their being, their lack of a conscience, which can't be fixed. Watch.
And then you showed him a videotape of something that I was doing?
No, not
and
a
you don't want to
videotape.
get my son involved?
I never said a videotape.
You just said right here he showed me some of it, and I lied because
I did not.
Got it? Good. Not done yet. Less than 5 hours later.
Okay? Don't worry about me much. You worry about yourself. You worry about yourself and telling your kids and showing them videotape. Okay?
I never seen one videotape.
Yeah, if Daddy starts to show you a videotape, I want you to run the other way because that's wrong for any individual, especially an adult, to do to a child. And he's already tried to do that with Alex.
I did.
You did do it. He even told me you did.
Got it? Good. Not done yet. Now, these personality types lie directly to the source as just seen. Yet you still missed many things, which Mr. Stengel can claim, with a 100% guarantee. What'll happen just in those 38 seconds? Let's watch it again, with some assistance.
And then you showed him a videotape of something that I was doing?
No, not
and you
a
don't want to
videotape.
get my son involved?
I never said a videotape.
You just said right here he showed me some of it, and I lied because
I did not.
Less than 5 hours later.
Okay? Don't worry about me much. You worry about yourself. You worry about yourself and telling your kids and showing them videotape. Okay?
I never seen one videotape.
Yeah, if Daddy starts to show you a videotape, I want you to run the other way because that's wrong for any individual, especially an adult, to do to a child. And he's already tried to do that with Alex.
I did.
You did do it. He even told me you did.
How well did you do? 1. She lied to what Alex said, directly to him. 2. He denies it. 3. Relentless, she tries again, now by bullying the source. 4. Alex angrily denies it, again. 5. She began fabricating that to Maya. 6. Maya denies it. 7. She then says, if 8. Accuses Mr. Stengel of wrongdoing while he is sitting there. 9. While she is doing just that. Allegations equals confessions. With the source there. 10. After number 1 to number 4, accuses Mr. Stengel, who is there, and source number 2. 11. Mr. Stengel says, I did. Basically denies it. 12. Relentless, she tries again, now by bullying the source, saying that he did. 13. Then states that Alex told her so. 14. Therefore, she even has a witness. However, the witness, like all their so-called witnesses, requires alienation. And a gag order, if one were to attempt to inform Alex, his name is being used in this manner. Which also demonstrates the very base of reality equals 0. Got it? Good. Not done yet. There are many remarkable and disturbing aspects of what was just seen. One being the complete disconnect from reality. The aggression and bullying tactics are easily permitted where a conscience would not allow such behavior. So mentally deranged, she confesses with her if statement at number 7. In essence, confessing it's all bullshit, and she is 100% aware of that fact. Yet, even after her confession, she continues on the attack with the same bullshit. Then adds a witness. The same witness that twice told her she is lying about what he said. Besides, her real problem is reality, documented. What's also clear is she is fine with the children being abused and living it live. Just not happy if they were to review her constant abuses against them. And Alex, now a witness. And, obviously, must be alienated. Which also demonstrates the need for their supervised visitation scam. Not just a need, rather a requirement. Must have some stranger standing within a few feet from Mr. Stengel and Alex Meyer at all times while taking notes and writing reports. Cannot allow Alex or Meyer hear any truths or reality and the abuses to them, their schools and communities. And must at all costs keep them inside this crime ring's virtual world and contained under their designed dome of delusion, forcing their systematic brainwashing via Nazi and cult-like tactics. Then, in order to further entrench their many other victims, point to their own psychotic and evil scam, the designed supervised visitation scam, saying,
See, that's how terrible Mr. Stengel is. He requires therapeutic supervised visitation.
Obtained by Dr. Catherine Killeen under oath on December 1, 2011, suborned by Mr. Leon W. Berg, swearing it is Mr. Stengel that disparages Miss Silisky to the children. The extreme opposite to reality. Reality, so well documented in Miss Silisky's own fraudulent protective order filings, sworn false testimony, and even in the months of videos taken inside the home and provided to them all. You will learn about extremes later in this presentation. And what about those visitation reports? As you will learn, in the Leon W. Berg, Confessions of a Child Predator presentation, were very bad for this crime ring. Alex noting the abuses to them all, also provided in his audio journals, even the letter Alex had written. Meyer's noted fear of her mother, noted in a police report, after witnessing the abuses. And their obstructing justice and abusing Boys Latin School, preventing the school from reporting Alex's reported abuses to the authorities, twice. As the abuses continued, and well over a year after their second intercept at Boys Latin School, some visitation reports noted Alex reporting being beaten up by Miss Silisky, hit in the stomach, and the back of his head, and stating it really hurts. Mr. Berg responds,
It's not enough to hurt the child.
What happened to that supervisor? Well, Mr. Leon W. Berg had to fire him, shutting and padlocking all gates, and keeping Alex enslaved for years. As Meyer was not physically beaten, but emotionally, spiritually, and psychologically abused, as they were force-fed their own experiences with their father, was simply delusional. Therefore, Mr. Berg, the psychotic, cowardly weasel, yet again, forces the ongoing abuses, with full knowledge, done so with malice, and intent to harm, and further harm, his minor clients, for which he demands to be paid. And Judith ENSOR agrees, as she was provided all of this information as well. In reality, all of their victims, and there are hundreds, including schools, the police, federal agents, and even an abuse organization, to name but a few, are simply pawns in their psychotic and evil alienation game. They have lots of witnesses. Surely the truth requires hundreds of witnesses. And Mr. Leon W. Berg, well, he constantly points to his so-called expert witness, Dr. Catherine Killeen, as if that's his get out of intentional frauds and abuses card, to his own minor clients, and the hundreds of other victims, which in his delusional world, apparently believes it also applies to his lies to schools, teachers, the courts, the police, and federal agents. This web of deceit spans way beyond your wildest imaginations, and the reason so many presentations are required. If just looking at number 1 to number 14, how well did you score? What are the odds of truth being told to others? 0%. That's how Mr. Stengel dissects psychosis, attacking and bullying her own children. Evil psychosis. Got it? Good. Not done yet. Less than 2 days later, November the 29th, 2010, Ms. Selesky's sworn filing. H.
He has shown video footage to my son, age 10.
Just after that, and in Cox's courtroom, and directly to her face, Ms. Selesky's sworn testimony. Testimony. 15.
He has been videotaping me in the house, and showed footage to the children.
Fact, filing said son, now children, plural. And, months prior to that November the 16th, 2015, gag order scam, Mr. Stengel provided Judge this Kathleen Cox with series number 1, episodes number 1 to number 7. Episode number 1 contains that November the 29th, 2010, filing and transcripts, laid out as scene, containing 75 actions. What you had just seen count as 1 in the filing, and 1 in the transcript of the over 2,000 documented. Judge this Judith ENSOR was provided these years earlier. You may now begin to understand. Mr. Stengel began documenting Miss Selesky and her psychotic, violent behaviors, but it quickly turned into documenting the actions of this crime ring, trafficking children, and coined the phrase white-collar child trafficking, and kept documenting. Of course, they all hate Mr. Stengel. What criminal wants to be documented?
Yeah. I'll tell you what, he's got enough money that he's very generous with Scott Stengel, his adult son, so he doesn't have to provide for him.
Judge this ENSOR is talking about Mr. Stengel's older son, when he visits, gets something to eat. However, the context of that statement is directly based on Judge this Judith ENSOR demanding Mr. Stengel have his adult son dismiss his replevin suit against Miss Selesky in order to retrieve his recorder Miss Selesky had his little sister steal, aka the stolen recorder. Mr. Stengel said he is an adult and can't force him. ENSOR then basically said, you have control. Stop feeding him. Here is the replevin action filed. Eventually dropped, as demanded by Judge this Judith ENSOR, and directly to Scott as well.
October 7, 2011. District Court of Maryland for Baltimore County. Plaintiff, Scott Eric Stengel. Defendant, Susan Selesky. Complaint. $5,000 or under. Checked. Replevin. Checked. Case number 0804003221822011. Susie Selesky had my 9-year-old sister steal my valuable audio recorder, which contained recordings left by myself, my 11-year-old brother and my father. Some of these recordings were patent ideas and other extremely sensitive information. My younger brother also used this as his personal diary, which in my opinion, was her motivation for obtaining the recorder. When I asked my sister why she took it, she explained, Mom told me to get it and bring it to her. She said she knew it was wrong, but she didn't want to be spanked, and yelled at by Susie, like her brother. I was also unable to bring this recorder to my 2.5-hour-long lecture. This entire event has caused me great anxiety and upset. This is not the first time Susie Selesky has used my 9-year-old sister to obtain things illegally for her. A police report has been written in regards to this matter. Number 112781404. Legal. Checked. Return of property, and damages of $5,000. Checked. Other. Punitive damages for teaching my 9-year-old sister to steal. Checked.
Scott dropped that suit. In fact, ENSOR demanded it be done during that lunch break, then told Scott to skedaddle. Then followed Scott to the district court, as if that suit has anything to do with her, or the divorce case she is presiding over. After numerous complaints to the Commission on Judicial Disabilities, Judge this Judith ENSOR was warned, yet remains in a chair titled Honorable. Warned. Someone may want to ask that commission to explain how honorable could be anything less, because either someone is honorable or they are not. Maybe the commission and their executive director Carol A. Crawford can explain how Judge Judith ENSOR can demand such an egregious action, yet not demand Miss Siliski return the stolen property, even though Miss Siliski refuses return it, and is therefore still in possession of stolen property. Or Judge Judith ENSOR is fine with Miss Siliski and Mr. Bradford. Why can't you retain possession of Mr. Stengel's stolen phone, which ENSOR mentioned Miss Siliski even lied to the police officer about? Or the many video cameras stolen, and still in possession of all of that stolen property as well?
West's Annotated Code of Maryland. Criminal Law. Title 7. Theft and Related Crimes. Subtitle 1. Crimes involving theft. Part 1. Theft. General theft provisions. Unauthorized control over property. A person may not willfully or knowingly obtain, or exert unauthorized control over property, if the person, 1, intends to deprive the owner of the property. 2. Willfully or knowingly uses, conceals, or abandons the property in a manner that deprives the owner of the property. Unauthorized control over property, by deception. B. A person may not obtain control over property by willfully or knowingly using deception, if the person, 1, intends to deprive the owner of the property. Possessing stolen personal property. C. 1. A person may not possess stolen personal property, knowing that it has been stolen, or believing that it probably has been stolen, if the person, 1, intends to deprive the owner of the property. 2. Willfully or knowingly uses, conceals, or abandons the property in a manner that deprives the owner of the property. Penalty. G. 1. A person convicted of theft of property or services with a value of 1. At least $1,000 but less than $10,000 is guilty of a felony, and 1. Is subject to imprisonment not exceeding 10 years, or a fine not exceeding $10,000 or both. And 2. Shall restore the property taken to the owner or pay the owner the value of the property or services. 2. At least $10,000 but less than $100,000 is guilty of a felony, and 1. Is subject to imprisonment not exceeding 15 years, or a fine not exceeding $15,000 or both. And 2. Shall restore the property taken to the owner or pay the owner the value of the property or services. Or 3. $100,000 or more is guilty of a felony and 1. Is subject to imprisonment not exceeding 25 years, or a fine not exceeding $25,000 or both. And 2. Shall restore the property taken to the owner, or pay the owner the value of the property or services.
And he has the Birch Lane home, which is only encumbered by a line of credit with his aunt. Now, everyone said Ms. Kramer just wasn't feeling well the day she testified, but she got up there. She doesn't know what she owns, she doesn't know what she literally, she was very surprised to learn that she owns any property, that being the 1% interest in the York Road property up in Warminster. She said she was just a signer of things. And she also said that she's loaned money to Mr. Stengel. She said there's this $200,000, I think it's a line of credit, and she explained that she just gets credit cards and spends them, reaches the max and then gets another interest-free credit card. I don't know, but she thought he owed her $50,000. I think he thinks he owes her $70,000, and the house is worth far more than that. And I'm telling you, I'm convinced there's other money as well. And he is the driving force behind this litigation, and I don't think he thinks he is. And that's one of the problems. I don't know if it's this diagnosed mental illness, but it's the kind of thing. He got up there today, and he's like, Mr. Levy's available. Leading me, he wants me to believe that Ms. Stengel has inappropriately kept his children from him. Well, Mr. Levy's not available. He's not. He's in synagogue. At any rate, I think Mr. Stengel could never, I don't have any great confidence he's going to agree with me or understand. I don't think he thinks. I think he thinks he's a victim. And I don't agree with that. He's to contribute $135,000 to Ms. Stengel's attorney's fees. I will reduce that to a judgment. Let us move on to Mr. Berg and Dr. Colleen's fees.
Covering all fraud bases possible. Besides, who obtains gag orders on mentally ill people? Why not allow him to talk, even if just to prove your point? unless Mr. Stengel is not mentally ill, but is documenting many that are, similar to all the court proceedings, as well documented in the official transcripts, where Mr. Carney constantly objects, yet Mr. Stengel allowed the constant rambling of false and contradicting statements, which gave rise to the well over 2,000 documented perjurious statements and false swearing. After all, why prevent a psychotic, pathological liar and serial perjurer from speaking, especially under oath and the penalty of perjury?
The parties stipulated that the work performed was necessary and that the fees charged as to each were fair and reasonable.
Huh? Really? The parties? Noting Mr. Lazaro is the moral and full crime ring member. Because you said on November the 26th, 2012, almost a year earlier.
Well, again, no, we're not going to revisit things, and your attorney and Mr. Carney agreed that Mr. Berg's fees were fair and reasonable and necessary, and that Dr. Colleen's were. That's not something we're going to revisit. Fair and reasonable. Fair and reasonable.
And just 3 days after that, and the same day as Mr. Carney's confession, Judge ENSOR is made fully aware. Mr. Lazaro is the crime ring's mole. Let's listen to Judge Judith ENSOR, on November the 30th, 2012, the final day of trial, talked to Mr. Rudo, Mr. Stengel's attorney at the time, about Mr. Stengel's previous alleged attorney, Robert Wayne Lazaro. Ms. Silisky files 0 income statements with the courts, suborned by Bradford G. Y. Carney, while earning loads of money from multiple businesses, such as her French tour business, A&M marketing, creative memories scrapbook business, rental property, and more. All provided to this court, and Judge Judith ENSOR. All while illegally collecting over $20,000 in fraudulent unemployment compensation. Another federal crime. Mr. Lazaro, involved in the case for well over a year. Mr. Rudo, involved just 3 days. Let's listen.
It's been entered into evidence.
I don't have any notes about unemployment, Mr. Rio, so it's not something that came up before you got in the case. It's not something that came up before you got in the case. It's not something that came up before you got in the case.
10-213. Evidence. West's Annotated Code of Maryland State Government. Exclusions. D. The presiding officer may exclude evidence that is, 1. Incompetent.
Mr. Robert Wayne Lazaro refused Mr. Stengel even call Miss Silisky a liar. In the appeal to the altered evidence trial, Mr. Lazaro was calling Miss Silisky a liar, forger, violent person, guilty of altering evidence, you name it. However, in the divorce case, where their frauds and scams were in full swing, he demanded by a written letter, Mr. Stengel not even call Miss Silisky a liar, or he can't represent him. As you just heard, Mr. Lazaro would not even bring up Miss Silisky's unemployment fraud, or anything. Mr. Lazaro has his own presentation summary, which includes that entire letter. Got all of that? Good. Okay, back to the November 26, 2012, hearing. As Mr. Stengel is representing himself, and their quashing of his subpoenas.
10-213. Evidence. West's Annotated Code of Maryland State Government. Scope of evidence. F. On a genuine issue in a contested case, each party is entitled to 1. Call witnesses. 2. Offer evidence, including rebuttal evidence. 3. Cross-examine any witness that another party or the agency calls.
Let's listen to Judge Judith ENSOR play Dr. Colleen's attorney, which was not the only time.
Okay. Now, Dr. Colleen.
Same thing. I mean, Dr. Colleen, I have not cross-examined Dr. Colleen, and she has, first of all, her bills are inaccurate, and I can prove that. That's number one, so it does have to do with finances.
You know what, again, no, we're not going to revisit things, and your attorney and Mr. Carney agreed that Mr. Berg's fees were fair and reasonable and necessary, and that Dr. Colleen's were. That's not something we're going to revisit.
But also Dr. Colleen was informed of a lot of things where by not looking at the right information which she was provided also catapulted more of this craziness that went on. Because if she would have just listened to, for instance, Alex, if she would have listened to me, if she would have listened to my son Scott, a lot of this stuff would have been prevented.
Okay, I understand.
And I think she should be questioned.
She understands, which is why she illegally prevents questioning the bills, and on that same day, comes this.
I have a question for Your Honor, if you don't mind. In relation to Mr. Carney's bills, am I able to ask him questions in regards to his bills?
No.
No.
Rule 18-202.2. Impartiality and fairness. A judicial appointee shall uphold and apply the law and shall perform all duties of the position impartially and fairly. B. A judicial appointee may make reasonable efforts, consistent with the Maryland rules and other law, to facilitate the ability of all litigants, including self-represented litigants, to be fairly heard. Comment. 1. To ensure impartiality and fairness to all parties, a judicial appointee must be objective and open-minded. 2. Although each judicial appointee comes to the position with a unique background and personal philosophy, a judicial appointee must interpret and apply the law without regard to whether the judicial appointee approves or disapproves of the law in question. 3. When applying and interpreting the law, a judicial appointee sometimes may make good faith errors of fact or law. Errors of this kind do not violate this rule.
So the only issue is how do you allocate them? The initial agreement was that Mr. Stengel would pay, subject to an allocation at trial. Now, Ms. Celeste is of the opinion Mr. Stengel should be responsible for the remainder of the bill, of all of it. And Mr. Stengel is of the mind that he has paid plenty, and that the remainder should be the responsibility of Ms. Celeste. Mr. Stengel has paid $26,000 to Dr. Colleen, and I think $20,000 now to Mr. Burke. It was $17,500 before, and then he got a check for $2,500. But there are significant bills outstanding. And again, I think that Mr. Stengel either can't or won't understand his role in this.
Oh, but he does, as mentioned numerous times.
Wait for the experts. Which experts are you referring to?
I don't know. It's a future thing. I'm just a gatherer of information. I'm just a gatherer of information. I'm just a gatherer of information.
This one is called Stump the Psycho, Carney.
This is one of my favorite ones.
Isn't it true, Mr. Stengel, that what your doctor referred to as your compulsive desire to document through videos and otherwise the crimes of your wife, that this was part of that endeavor? To pull these checks out, accuse her of misappropriating it at best, stealing at worst, from what you characterize as your non-marital real estate account, when in fact it was for household issues and tuitions and your kids.
Okay, it's two questions. So should I ask the first one?
Sure, go right ahead.
Okay, so I'll answer the first question. The first question is that because I'm OCDC doesn't mean that what I'm gathering is not accurate. Okay, that's the answer to the first question. And what was the second question?
I'll move on, Mr. Stengel.
Okay.
The number of emails that people had to review.
Say it again.
The number of emails that people had to review.
Over 484 emails. Presentation covers that well. However, on that very day, Judith ENSOR stated this.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed, and I considered the rates charged. Part of that review, frankly, was with an eye to determining who was actually driving the litigation. And of course, for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find the hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable. I find that of the almost $200,000 in legal bills, much is attributable to inappropriate actions on the part of Mr. Stengel.
Emails. And, line by line. How many lines are needed, for reality? The very first invoice, and even if we skip many that note email from Susie, there are 15 lines on page number 1. And continue, line by line, on page number 2, line number 11. Mr. Carney's bill notes.
December 23, 2010, read, study and print 38 emails from Susie and many third parties, 4.00 hours, for $1,500.
$1,500. And only 6 days into the action, and only 26 lines down. 38 emails, in one shot. Notice the
and many third parties.
part. Harassing and wrongfully involving others. As many as possible, via smear campaign, after smear campaign. Also known as the con. And in Mr. Stengel's research, redirect the focus. Then, attack. Note, Mr. Stengel can do this over 2,000 times. Yet they collectively can't do it once.
He wants to go on about, the padding with bills, but...
Say it again.
He wants to go on about, the padding with bills, but...
Only 13 lines before that.
The party stipulated that the work performed was necessary and that the fees charged as to each were fair and reasonable. He wants to go on about, the padding with bills, but the party stipulated that the work performed was necessary and that the fees charged as to each were fair and reasonable. He wants to go on about, the padding with bills, but...
First she repeats her mantra, Mr. Lazaro and Mr. Kanye agreed. Yet she is fully aware, and provides it in an obvious confession. Mr. Stengel was never heard.
Rule 18-202.6. Ensuring the right to be heard. West's Annotated Code of Maryland. Maryland Rules. A judicial appointee shall accord to every person who has a legal interest in a proceeding, or that person's attorney, the right to be heard according to law. Comment. 1. The right to be heard is an essential component of a fair and impartial system of justice. Substantive rights of litigants can be protected only if procedures protecting the right to be heard are observed. 2. Increasingly, judicial appointees have before them self-represented litigants, whose lack of knowledge about the law and about judicial procedures and requirements may inhibit their ability to be heard effectively. A judicial appointee's obligation under Rule 18-202.2 to remain fair and impartial.
He is just papering to death and then complaining that it's like he doesn't fully understand the volume of the information he's providing, and then he finds fault if people review it and expect to be paid for it.
Really? Because it appears the papering, as you call it, came from things such as this.
Because as Mr. Fetter said, to ferret out the lie, you've got to do more work. And the more work I did, the more frustrating it became because I just kept coming up empty.
Which was derived from things such as this.
Read, study and print 38 emails from Susie and many third parties, draft various email responses. 4.00 hours, for $1,500.
Various email responses. Plural. That 38, most likely turned into 50 or so. Although this is a small portion of one page, it's hard to miss the obvious, especially if one were to go line by line. Only 5 days into the action, Mr. Carney's bill notes.
Read and approve Rabbi Fink's affidavit.
1 day later.
Prepare affidavit for Rabbi Fink.
They already had their meat hooks into this rabbi. Remember his name. Rabbi Fink. As you will not believe all the things they conned this rabbi into. Which answers another knowingly false allegation, such as this.
He is the driving force behind this litigation.
Therefore, can provide evidence of papering and driving. Driving while papering. Papering while driving. With evidence such as this.
Most of the 36 years that you've been a lawyer, and I think all of the 35 years that I've been a lawyer. And have I been known as a person who tries cases on a regular basis as opposed to a person who settles cases or files motions and then settles cases for the most part? Yes.
And his own expert confirms it. Apparently, you enjoy riding the delusional trolley, which surely feels like home. However, if we can possibly get it to stop at Reality Boulevard, which it can't, we would see that Mr. Stengel provides organized presentations. And, just in case needed, it's also categorized, so for example, he can do this. On July the 22nd, 2013, page number 48 of 50, in Mr. Berg's response to the commission, notes as number 5b, he writes,
I forwarded all of the information, which he provided to me, to Dr. Killeen, though typically, he would provide her with a duplicate copy.
Note, on top of Miss Silisky knowingly bombing everyone with emails, along with Miss Silisky and Mr. Carney, conning, harassing and abusing others to do the same, in order to abuse her own children. Now, 2.5 years after their fraud began, Mr. Berg, for the first time, mentions he did his part. Quietly. Mr. Berg confessing to bombarding Dr. Killeen with what he confesses he was already aware was provided to her. Dr. Catherine Killeen, obviously aware she already has the information, happily accepts the duplicates, time and time again, from Mr. Leon W. Berg. Yet Dr. Killeen fails to mention this, as well. Besides, to dissect Mr. Berg's response, just a bit more, it wasn't Mr. Stengel that provided Dr. Killeen with a duplicate, rather her own copy. Those were Mr. Berg's covert actions. This is detailed in the over 484 emails presentation. That presentation left everyone wondering, and with a question for you, Judge ENSOR. What happened to Joe?
What happened to Joe?
So then what happened to Joe?
Surely you'll notice this confession was only 2 months before this decision day. Even with the added 2 months, Mr. Berg still did not clean up that repeated fraud, did he? Just to be clear, these can all be done on the fly, and your 3 pages we are reviewing can easily be dissected, as you say, line by line. In fact, often, word by word. However, these 3 pages would take over 10 hours, and I don't believe that many rectal exams are needed for this presentation. Apparently, you do not take your own advice, as it was you, Judge Judith ENSOR, that said.
Mr. Stengel is the kind of person that I would have to be very careful with my words.
Let's listen to it in its entirety.
He is just papering me to death, and then complaining that it's like he doesn't fully understand the volume of the information he's providing, and then he finds fault if people review it and expect to be paid for it, and then further find fault if they don't agree with his position regarding it.
Dr. Alan Kimmel, Ms. Stegel's medical doctor, aware of Ms. Stegel's mental health issues.
Contrary to what Mr. Rudo said, very little of my perspective on this case had much to do with what Ms. Zaleski said, or didn't say, or did, or didn't do. Very little of my perspective on this case, very little,
opposed to 0, having to do with what Alex said, or did, or provided, or what Maya said, or did, or what the police reports provided, or what Mr. Stengel actually said, or actually did, or actually provided, or what the videos taken inside the home, over many months prior, showed, time and time again, or didn't show, such as Miss Zaleski's insane number of false allegations of abuse, in her multiple fraudulent filings.
Very little,
opposed to anything provided by Garrison Forest School and their years of internal memos. Then you intentionally abuse their school, teachers, and staff, as with Boyce Latin School, teachers, and staff, etc., etc., etc.
Very little,
opposed to even one thing provided by Mr. Karseski to the state of Maryland, a 148-page package containing just some samples of Miss Zaleski's career of crimes. That sampling had the state of Maryland surrender, and the state had Miss Zaleski, their star witness, magically disappear. Was she being hidden in a bunker? Because Dr. Killeen falsely testified it was Mr. Stengel's bunker mentality.
Very little,
even though Mr. Berg states
very little,
Mr. Berg has yet to provide the
very little.
Besides, Mr. Berg and Dr. Killeen were provided many of these by Mr. Stengel at Alex's request, and later provided to Mr. Carney, Mr. Lazaro, and ENSOR herself by Mr. Stengel.
Today's June 1st, 2011. I'm with my dad. It's on Wednesday. It's around 8:30 p.m. And it's been really crazy that past 2 days. Mom called the cops. There's the cop cars because of backpack and paper bags. Earlier before that, Mom was when she got angry at me because I was talking something, forget what, and then I was in my bed and she showed me what Dad did, which was a lie, complete lie. She twisted my arm on purpose. She twisted it hard, and I'm really hurt, and she started poking me the heck out of me really hard. Really hurt. It's been just crazy. She flips out every second, and she's trying to bribe me not to talk to it. It's crazy. So that's what's happening. So frustrated about it. Anyways, Scott's in Aruba, and every now and then I sing the song Aruba, Jamaica. Ooh, I wanna take her to the Uber, Bahama. Come on, little mama, Bahama. If I take her, you know that? Yeah, that's what it is. Alright. It's August 26th at 9 a.m. and if anyone hears this, I just want to stay with my dad. By that I mean like full custody with my dad.
1. Definitions. 1.1. Child's best interest attorney. Child's best interest attorney means a lawyer appointed by a court for the purpose of protecting a child's best interests, without being bound by the child's directives or objectives. This term replaces the term guardian ad litem. The child's best interest attorney makes an independent assessment of what is in the child's best interest and advocates for that before the court, even if it requires the disclosure of confidential information. The best interest attorney should ensure that the child's position is made a part of the record, whether or not different from the position that the attorney advocates.
Important notes. A. Independent assessment. B. Should ensure that the child's position is made a part of the record. C. Whether or not different from the position that the attorney advocates.
2. Responsibilities. 2.2. Child's best interest attorney. A child's best interest attorney advances a position that the attorney believes is in the child's best interest. Even if the attorney advocates a position different from the child's wishes, the attorney should ensure that the child's position is made a part of the record.
Important notes. A. Advances a position that the attorney believes is in the child's best interest. B. The attorney should ensure that the child's position is made a part of the record.
Dr. Alan Kimmel, Ms. Steggle's medical doctor, aware of Ms. Steggle's mental health issues.
And what about this?
You don't even let your wife talk, ever. You don't even let me, because that's what it feels like. When you talk, I do too. What?
And what about this? Now, to her own chest.
Throwing daggers in my fucking heart!
Dr. Alan Kimmel, Ms. Steggle's medical doctor, aware of Ms. Steggle's mental health issues.
Months! And the other day you told me, I don't even know how long ago it was, you told me you're done with sex,
and what about this?
Gotcha. Got me what? Okay, you have no idea who I am. You have no idea who I am. Hopefully.
And what about this?
So that you know, and that we're very clear on this, I don't want a divorce. So changes what numbers? You can't afford to send your kids to good schools, and yet you're going to keep them in a school district that's going to become black, like Newtown and Randallstown.
Dr. Alan Kimmel, Ms. Steggle's medical doctor, aware of Ms. Steggle's mental health issues.
Because I realize I'm a fraud! I'm a fucking fraud! You're an asshole! I'm a fraud! You fucking asshole! I hate you! I don't want to be your goddamn fraud! You're not the fucking piece of shit anymore! I'm not your fraud! Your father and I are definitely divorcing. Yeah, you just told me tonight.
And what about this?
I'm kind of screwed in this way because he hasn't physically hurt me.
Dr. Alan Kimmel, Ms. Steggle's medical doctor, aware of Ms. Steggle's mental health issues.
Oh my God! Imagine the possibility of doing something with someone.
How can I experience this?
Don't see how you're taking it. I told you, and I will tell you again. I have said to you, put it all in another name. Write a document and I'll sign it. For me, it's that guy it's like a mirror. Because you don't listen, you're dead. You're dead. Listen. You're not listening. Excuse me. It's you not listening.
I'm kind of screwed in this way because he hasn't physically hurt me.
So we'll go talk in another room. And he
But I
didn't.
want to know the best way to deal with the kids.
Okay.
This is
Look,
not,
this is very simple. This is very, they're already destroyed.
You don't even let your wife talk, ever. You don't even let me, because that's what it feels like when you talk. I do too. Mark!
At any rate, I believe Mr. Berg's outstanding fee is $37,095. I think Mr. Stengel's already paid $20 of the amount remaining. Ms. Stengel's to pay $11,419. Mr. Stengel's to pay $25,676. I'd be happy to reduce that to a judgment.
May I have those numbers again, Your Honor, please?
You may. I believe the outstanding fees are $37,095. I think $20's been paid by Mr. Stengel, and the remaining amount is to be divvied up as follows: $11,419 to be paid by Ms. Stengel, Mr. Stengel to pay $25,676. With respect to Dr. Colleen's bill, Mr. Stengel's paid $26,000 of her nearly $50,000 bill. I do find, again, the majority of the work was resulting from the actions or inactions of Mr. Stengel.
Really? Because
I'm just a gatherer of information.
now, for the first time ever, Mr. Stengel is being accused of inactions. What specifically was Mr. Stengel to do that he did not do that caused all these bills? Because that's the complete opposite of your allegations, for which you are attempting to justify your fraud.
He is to pay off this remaining amount, $13,856, and Ms. Stengel's paid $9,965. I think that's everything.
Really? Miss Silisky is to pay $21,384. Really? For all the intentional fraud? Who pays the taxpayers, abuse organization, schools, her countless victims, and others, back? Also important to note, Miss Silisky, aka Ms. Zero Income, paid Mr. Berg and Dr. Killeen that $21,384 within a week or two. Which raises the question, who did she con that money from? As an urgent matter, of course. And Mr. Stengel hasn't paid any of these thugs one dime. And the golden fraud key.
Your Honor, it's all been snowballed. I mean, the whole entire thing has been created out of thin air and fabricated and then snowballed and involving all these people that they don't even know that they've been involved. They don't even have any idea what Susie has done to these people and involved their families. And not only, she's created expenses for the Ospreyers who come with an attorney, Your Honor. I mean, it doesn't end. This started and it hasn't stopped because she won't stop. She just won't stop.
Well, I think she would say that you won't stop.
Well, I can prove, see, but that's the difference.
That's where we are with this.
Right, but that's the difference. I have evidence and she doesn't. I have evidence and she doesn't. I have evidence and she doesn't. I have evidence and she doesn't.
Neither do any one of them. Not one piece. As just heard, on page number 27, Mr. Stengel advises Judge Judith ENSOR, many people have been used, abused, and conned. Also stated, they have no idea. Therefore, Judge Judith ENSOR is also aware of the many victims of identity theft and identity fraud committed by Miss Silisky.
Involving all these people that they don't even know that they've been involved. They don't even have any idea.
Also unimaginable is the number of years of prison time accumulated by this gang. What happened to? You do the crime, you do the time. Apparently, this crime gang is exempt. Besides, who can keep track of all the years being accumulated? Maybe the Guinness Book of World Records will be able to.
West's Annotated Code of Maryland. Criminal Law. Title 8. Fraud and Related Crimes. Subtitle 3. Identity Fraud. Identity Fraud. Prohibited. Assuming identity of another. C. A person may not knowingly and willfully assume the identity of another, including a fictitious person, 1. To avoid identification, apprehension, or prosecution for a crime. Or, 2. With fraudulent intent to, 1. Get a benefit, credit, good, service, or other thing of value. Restitution and costs. G. 1. A person who violates this section where the benefit, credit, good, service, health information or health care, or other thing of value. 3. A person who violates this section where the benefit, credit, good, service, or other thing of value, that is the subject of subsection B, C, or D of this section, has a value of $100,000 or more, is guilty of a felony, and on conviction is subject to imprisonment not exceeding 25 years, or a fine not exceeding $25,000 or both. 5. When the violation of this section is pursuant to one scheme or continuing course of conduct, whether from the same or several sources, the conduct may be considered as one violation, and the value of the benefit, credit, good, service, or other thing of value, may be aggregated in determining whether the violation is a felony or misdemeanor.
All crimes authorized and approved by Judge Judith ENSOR and many others. Obviously, Judge Judith ENSOR is reading a choreographed script, a script which took nearly 10 months to write. This part alone could have easily been dissected for hours. However, you may have seen or can see some of the presentations, such as Introduction to Bradford County Fraud Billing Scam, State of Maryland vs. Mark Stengel, Karseski 148-page package, Confessions of a Circuit Court Judge, Kathleen Cox Targets Jewish and Other Communities, Leon W. Berg, Confessions of a Child Predator, How in the World, Maya's 9th Birthday Abuse and Conspiracy Scam, Authorized Child Abuse Forced, The Stolen Recorder, over 400, or 84 emails, the same wrong answers. Alison Meister Friedman, Happy Halloween, and Boys Latin Fall Fist Staged Scam and Perjury. Berg Trifecta, now Ashma, Thorough. Supervised Visitation Scam. Boys Latin School of Maryland, Used and Abused, Rinse and Repeat. And many others, such as Stengel Arrest, Prison Reality of Experience and Those Responsible. Bradford County covertly represents police and sheriff's departments. Fraud via the Dr. Eisenberg fiasco. Stuart Zolotoro, Introduction and Details on How to Con a Photographer. The False Bruce fiasco, conning and setting the staging at the Weinbergs. Who is Susan? Who is Susan? My name is not Susan, with State's Attorney and John P. Cox letter. Tossing the subpoena court on tape starring Susan Silisky. Mental illness and the Dr. Kimmel scam. Estimated list of gotchas and no way outs. How to be white and commit over 2,000 criminal counts, and keep going and going. Dr. Catherine Killeen plays hide the fraud bills for nearly 7 months. Fraud, intrinsic, extrinsic, and XYZ-trinsic. How many witnesses required for 2 + 2 to equal 4? 100, 200, 300 or more. The State of Maryland versus the public. And many more. Besides, we will look at just a couple samples. Mr. Leon W. Berg begins on January 6, 2011. Dr. Catherine Killeen begins on January 7, 2011.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed, and I considered the rates charged. Part of that review, frankly, was with an eye to determining who was actually driving the litigation.
The custody trial was set for December 1, 2011, where Dr. Catherine Killeen would testify as the child custody evaluator and expert. Mr. Robert Wayne Lazaro, the mole, was specifically hired for this reason, yet bailed at the appropriate time, as he did many times afterwards. All detailed in other presentations. Bradford G.Y. Carney's bill dated December the 5th, 2011. Payments received since last invoice. 0. We look at page number 3 of 3. Collusion lunch. Notes.
Vendor Bradford Carney, invoice number 32627221, miscellaneous. Meeting with best interest attorney at Cafe Troya, on November 3, 2011. For $31.16.
This, just weeks before Dr. Killeen's fraud testimony on December the 1st, 2011, as Mr. Berg's only witness. Mr. Berg enjoys a collusion lunch with his crime ring partner, Bradford G.Y. Carney. Both demand Mr. Stengel should pay for it. Judge Judith ENSOR agrees. Dear Judge Judith ENSOR, if one of them, or both, choked to death on that lunch, would Mr. Stengel be responsible for that as well? The bottom of the invoice notes.
Total of new charges for this invoice: $16,647.36.
That's what many complete divorces cost. However, with Mr. Carney, it's just 1 month. To be completely fair, that amount includes all the collusion, conspiracy and other criminal actions. Miss Silisky pays $0.00, with a balance now exceeding $100,000. Is any one of these actions fair and reasonable, let alone all of them? Welcome to the Spread the Fraud Sheets bills, which are a side-by-side spreadsheet that reflect their actual bills. There are 130 pages. On page number 75, for time's sake, we will only focus on number 13 and number 14. 13. Mr. Carney's bill notes.
November 28, 2011, call from Elberg regarding order of witnesses, nature of Killeen's testimony and general trial preparation.
0.30 hours, for $112.50. Note, collusion, conspiracy, fraud, and more. You will notice, Mr. Berg's column/bills do not reflect his actions. 14. Mr. Carney's bill notes.
November 28, 2011, read email from Susie regarding her desire, not let kids testify.
0.30 hours, for $112.50. Note, collusion against children. Do not let the kids have a say, right Mr. Berg? Hell no. As always, the Spread the Fraud Sheets bills reflect their actual bills.
November 28, 2011, call from Elberg regarding order of witnesses, nature of Killeen's testimony and general trial preparation.
I studied the descriptions.
It's important to know, a case is not assigned to a judge until the day before, around 3 p.m. This is done for many reasons. Why is this important to know? Because it shows their collusion and conspiracy of hoodwinking the judge and court is targeted at abusing any and all the judges. With this crime ring, it's whichever judge draws the short straw. They will collectively attack, like a vulture, on a half-eaten carcass on the side of the road. Then use the judge's ruling to hoodwink other judges and the system. Got it? Good. In this case, it was Judge Timothy Martin. 16. Dr. Killeen's bill notes.
November 29, 2011, trial preparation with Mr. Berg, review DVDs The Truth Regarding Susie, transcripts plus actual events, review website susatube.com, thebrucefiasco.com.
11.00 hours, for $2,750. Note, evidence and presentations provided several months prior, and evidence, Dr. Killeen received the evidence. 17. Mr. Berg's bill notes.
November 29, 2011, meeting with Dr. Killeen.
5.75 hours, for $1,725. Note, meet with Dr. Killeen for collusion with Mr. Carney. Only a couple days before trial. 18. Mr. Carney's bill notes.
November 29, 2011, trial preparation, call from Elberg at Killeen's office regarding trial procedure/strategy.
0.40 hours, for $150. Note, collusion connects all three. Collusion Incorporated. Berg goes to his only called expert witness Dr. Killeen's office, where from Killeen's office, Leon W. Berg calls Mr. Carney to discuss strategy. These are just small samples, as their bills are laced with this and other fraud and abuses to everyone. Nothing. In comparison to their other insane number of crimes. and the reason they must falsely incarcerate Mr. Stengel and brainwash others to assist, and their unauthorized use of many names, schools, and organizations, known as identity theft, to commit more crimes, and must, at all costs, illegally remove Mr. Stengel's First Amendment rights. They all forgot to mention, each line item in each of their bills is an order for services for which they demand payment. Therefore,
West's Annotated Code of Maryland. Criminal Law. Title 8. Fraud and Related Crimes. Subtitle 6. Counterfeiting and Related Crimes. Counterfeiting of orders for money or goods. Order for money or goods defined. A. In this section, order for money or goods means any writing, ordering, or requesting for the payment of money, or the delivery of goods. Prohibited. B. A person may not 1. With intent to defraud another, cause or procure to be counterfeited, or willingly aid or assist in counterfeiting an order for money or goods. 2. With intent to defraud another, issue, publish, or pass a counterfeit order for money or goods, if the person knows it was counterfeited. Or 3. Knowingly and fraudulently obtain money or goods, by means of a counterfeit order for money or goods. Penalty. C. A person who violates this section is guilty of a felony, and on conviction, is subject to imprisonment for not less than 2 years, and not exceeding 10 years.
Note, there are hundreds and hundreds and hundreds of orders. Papering while driving. Driving while papering. The paper manufacturers. Surely they all mentioned all of this to the hundreds they are protecting. Surely one of them mentioned all of this. Surely one of them mentioned just one action in its proper context. No matter how much you have viewed and how many presentations you have seen or will see, always, always, always remember. Okay, let's do another sample. Dr. Killeen's fraud testimony, exceeding 100 false statements, was provided on December 1, 2011, and suborned by Mr. Leon W. Berg. Trial set for May 2 and 3, 2012, to be cross-examined. Therefore, Dr. Killeen was still on the stand. December 1, 2011, custody hearing to continue.
Descriptions of the work performed.
Leon W. Berg, PA, May 1, 2012. Mark Stengel. Bradford G.Y. Carney, Esquire. Note, the first line in Mr. Berg's bill notes.
April 12, 2012, Appeal de novo, Protective Order Hearing. 2.00 hours, for $600.
We will come back to this shortly, as it is more than enlightening. Next. Mr. Berg's bill notes.
April 26, 2012, telephone call with K. Killeen, and B. Carney, Esquire. 1.00 hour, for $300.
Note, Mr. Berg's only called witness, still on the stand, Dr. Killeen and Mr. Carney. Just 6 days before trial, colluding and conspiring. A fraud trifecta. Mr. Berg's bill notes.
April 27, 2012, meeting with K. Killeen. 1.75 hours, for $525.
Note, another covert action. These are the people that harassed and abused the schools, and countless teachers and staff, and never provided any of the records to the courts. Such as the Garrison Forest School records, with years of Miss Sileski's outrageous actions and behaviors, as that did not fit into their agenda. They never told the schools, or anyone, they were simply looking for dirt on Mr. Stengel, and as already heard, they kept coming up empty. This detailed in the Garrison Forest School fiasco presentation, and portions shown in other presentations. We continue to go line by line. Mr. Berg's bill notes.
April 28, 2012, trial preparation. 3.75 hours, for $1,125.
Note, preparing to commit more fraud upon the courts, and against his minor clients. Mr. Berg's bill notes.
April 30, 2012, telephone with K. Killeen and B. Carney, Esquire. Trial preparation. 2.90 hours, for $870.
Note, 2 days before trial. More collusion and conspiracy, against everyone they wrongfully involved, with foreknowledge and malice, including Mr. Berg's minor clients, followed by more preparing to commit more fraud upon the courts. Important, the synopsis line above is detailed in another presentation. In short, Mr. Berg did not like what 7 transcript pages from Dr. Killeen's sworn testimony on December 1, 2011, said, so he removed those and made up his own synopsis. One included Alex reporting being beaten up by his mother to his school, boys' Latin school, where Mr. Berg sent Dr. Killeen to the school, obstructing justice, and prevented the school from reporting the abuse to the authorities. Alex reported being abused to his school on 2 different occasions, with the same results. Mr. Berg's bill notes.
May 1, 2012, trial preparation. Telephone with B. Carney, Esquire. 0.60 hours, for $180.
Note, the day before trial, Mr. Berg prepares to commit more fraud upon the court, then conspires with Miss Zaleski's attorney, apparently for verification. Important. As you can see, Mr. Stengel refuses to pay Mr. Berg, yet he refuses to get out of the case. The alienation game. Use them. Abuse them. Alienate them. Just like this one sample, and the other few sample bills in the days leading up to Dr. Killeen's fraudulent sworn testimony on December 1, 2011, under oath and the penalty of perjury, the crimes repeat. However, even if we only focus on this one sample, surely what we already heard makes sense, does it not?
The parties stipulated that the work performed was necessary and the fees charged as to each were fair and reasonable.
Add to that.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed. The parties stipulated that the work performed was necessary and the fees charged as to each were fair and reasonable. Fair and reasonable. Fair and reasonable. I went through the bills. I went through them line by line. I studied the descriptions of the work performed. I went through the bills. I went through them line by line. I studied the descriptions of the work performed. I went through the bills. I went through them line by line. I studied the descriptions of the work performed.
Which is a confession of your own fraud, and your role in all the frauds perpetrated upon Mr. Stengel, Alex and Maya, the hundreds of victims, and society, for 5+ years, and going. In 2011, 2012 and so on. Mr. Stengel documented warning you, and the others, there is no way out, and being reduced to trapped lab rats in Mr. Stengel's ongoing research of inside the minds of evil psychosis.
The parties stipulated that the work performed was necessary and the fees charged as to each were fair and reasonable. Necessary and the fees charged as to each were fair and reasonable. Fair and reasonable.
Judge Judith ENSOR uses Mr. Lazaro as her validation to Mr. Berg and Dr. Killeen's bills being fair and reasonable, instead of Mr. Stengel himself, who has evidence to the contrary. Wouldn't having gone line by line, herself provide the answers? In which case, why would it matter what anyone said? Correct. Because a judge's #1 job, not #2, but job #1, is to get to the truth. Just to clarify this, if Mr. Lazaro and Mr. Carney agree, 2 + 2 = 5, then in a court of law, the answer is 5. And if you going line by line, bears out the truthful answer, which is 4, then, what's a circuit court judge to do? And what about this? Let's look at the fair and reasonableness in Dr. Catherine Killeen's line item bills, in the days leading up to the child custody trial from December 1, 2011, being resumed and scheduled for May 2, 2012, and May 3, 2012. Specifically, to have Dr. Catherine Killeen cross-examined on her insane number of false and fraudulent testimony. Scheduled to be cross-examined by Robert Wayne Lazaro. Since December 1, 2011, was scheduled to resume, technically and ethically, Dr. Catherine Killeen is, and has been, still on the stand, only 6 days before Dr. Catherine Killeen is to retake the stand. Dr. Killeen's bill notes.
April 27, 2012, file review. 3.00 hours, for $750.
obviously preparing to be cross-examined by Mr. Robert Wayne Lazaro.
Meeting with Mr. Berg, telephone call with Mr. Lazaro, telephone call with Ms. Sileski. 3.00 hours, for $750.
Where do we start? Not line by line, rather words by words. 1.
Meeting with Mr. Berg.
Note, just as noted in Mr. Berg's bill, further confirms the illegal and fraudulent actions by both Mr. Berg and Dr. Killeen. Mr. Berg's bill noted, this lasted 1.75 hours. That leaves 1.25 hours for the remainder of the illegal conversations. 2.
Telephone call with Mr. Lazaro.
Mr. Lazaro, what could Dr. Catherine Killeen and Mr. Robert Wayne Lazaro, who is allegedly to be cross-examining Dr. Catherine Killeen in 6 days, possibly be talking about? While technically still on the stand, Dr. Killeen is speaking with the opposing side. Really? 3.
Telephone call with Ms. Sileski.
Now, Dr. Killeen is speaking with the defendant herself. It's a full-out fraud circus. And the key part in all of this, Judge Judith ENSOR states, all of their outrageous bill amounts are Mr. Stengel's doing, such as the emails and what she called papering them to death. Even though all of the doing is behind Mr. Stengel's back and in fraudulent criminal actions. Regardless, Mr. Stengel is responsible and should pay. Only 3 days before Dr. Catherine Killeen is to retake the stand, Dr. Killeen's bill notes,
April 30th, 2012, interview with Alex. 1.00 hour, for $250.
Besides, 1. Still being on the stand. 2. Alex could be called as a witness. 3. Dr. Catherine Killeen swore she had completed her evaluations, therefore could make a covert school decision for mine in late September 2011. 4. Therefore, testify as an expert on December 1, 2011. 5. Stated, she was done gathering data, as would be required, in order to complete her so-called evaluations. So, why was Dr. Killeen harassing Alex? Besides, Alex already made his wishes clear on numerous occasions. On 2 occasions, begged his father to take him to talk to a judge, not wanting to go back to his mother. Mr. Lazaro said, Mr. Stengel must take him to Mr. Berg. After both times, Alex stated,
that was a waste of time. Can you please take me to talk to a judge now?
He has never actually refused to go over to her house. So
besides what is known as the paragraph, and the only information provided to Judge Martin in regards to Miss Sileski, which you will hear later in this presentation, that statement, and listening to her tone of voice, sit down for this one, was the only positive thing she said about Miss Sileski. Yes, positive. Listen again.
He has never actually refused to go over to her house. So
there is more. There is always more. And yes, relating to that statement. Besides everything else, Mr. Berg and Dr. Killeen knew, there is also what occurred just 3 days prior, which you will learn in another presentation. We continue. It's all in line with their constant, collective, child predatory, and intentional abusive actions from day one, like conning, hoodwinking, and lying to hundreds of people and organizations, especially Judge Timothy Martin, even using the names of many people and organizations without their knowledge or consent, staging a covert scam at Boys Latin School during their annual Fall Fest event, even using Garrison Forest School's name in court on December 1, 2011, and attaching knowingly false information to the school's name, therefore their reputation, simply to complete another pre-designed agenda. What's their agenda? Remove Mr. Stengel from his children's lives, and the children from their father. At the time of this trial preparation scam, May 1, 2012, due to sworn, false testimony provided on December 1, 2011, and suborned by Mr. Berg, Mr. Stengel hasn't had any communications whatsoever with either of his children in 5 months, nor the children with their father. Surely, Alex wanted to talk to Dr. Killeen, knowing full well what he had repeatedly been telling her and Mr. Berg all along was not only ignored, but she and Mr. Berg did the complete opposite. So, what was that call about, if not for their ongoing psychological warfare against children and their communities strategy? Then, on December 1, 2011, in an allegations equals confessions reality moment, confessed to them doing just that. Dr. Killeen's bill notes.
Interview with Maya. 0.60 hour, for $150.
Besides 1 still being on the stand. 2 who could be called as a witness. 3. Dr. Catherine Killeen swore she had completed her evaluations. 4. And was done gathering data. That's 4 reasons this line-by-line item is both illegal and unethical. Yet is somehow Mr. Stengel's doing. And it was Maya's turn to have her own experiences explained as delusional, and their delusion, in cooperation with Miss Silisky, of course, forced down her throat, which must, at all costs, be her reality. Dr. Killeen's bill notes.
Court preparation. 3.00 hours, for $750.
Really, Dr. Catherine Killeen? The very day before Dr. Catherine Killeen is to retake the stand, Dr. Killeen's bill notes.
May 1, 2012, telephone call with Ina Basefeld, Alex's therapist. 1.00 hour, for $250.
What could possibly take an hour, the day before Dr. Catherine Killeen is to retake the stand, if not gathering data?
I know. It's one psychologist, brainwashing the other psychologist session.
Telephone call with Peggy Kolodny, Maya's therapist. 1.00 hour, for $250.
Again?
It appears so. Or should we say, one psychologist, brainwashing the other psychologist session.
Telephone call with Mr. Berg, Mr. Lazaro, and Mr. Carney. 1.60 hours, for $400.
The only one missing is Judith ENSOR.
What about Dr. Catherine Killeen's report? Originally due in August 2011, then again, prior to the December 1, 2011 trial, with enough time to have it reviewed by another expert. Now another 5 months later. Where is that report?
Well, in August 2011, there are reasons A, B and C. They haven't clarified which one of their conflicting stories was in the lead in that fraud race. And prior to Dr. Killeen's fraudulent testimony on December 1, 2011, she billed for 39 hours, yet no time for her contractually obligated report for third-party outside review. Apparently, that is fair and reasonable. Now, just in Dr. Killeen's bills, 14.20 hours spent and over $3,500 billed, leading up to this obvious fraud, by way of committing more fraud. And you are correct, 5 months later, and still no contractually obligated report for outside third-party review. In which case, going line by line isn't really needed, is it? Why bother going line by line, when it's obviously all Mr. Stengel's doing, which gave rise to these outrageous bills? Apparently, Mr. Stengel's actions are so demonstrative, his actions required everyone else, besides Mr. Stengel, to conspire and collude against Mr. Stengel and his children. And, without having the specific rule of law that applies, given they all agree, supersedes having to provide what specifically Mr. Stengel's demonstrative actions were.
Excuse me. Excuse me. You said, actions. Plural. That implicates there is more than one.
Right. This collective agreement, by the same group, also supersedes simply showing specifically, even one, of what Mr. Stengel's demonstrative action was. And, whatever that rule of law is, simply add a -1. Then, it will also apply to it being fair and reasonable. Counterfeiting carries a minimum of 2 years in prison. Let's repeat that. Counterfeiting an order carries a minimum of 2 years in prison. One must wonder what will happen with hundreds of orders. Surely, these criminals must be thinking, or planning to say, we didn't counterfeit anything.
We actually had those conversations.
We actually did that work.
Makes sense, if one were to ride a delusional trolley. However, that would be like saying,
Can I take a crack at this one?
Sure.
That would be like saying, we went to the printing press, turned on the machine, and printed the counterfeit money. So we did the actual work.
Exactly. Manufacturing money, or manufacturing fraudulent reasons to obtain money, is the same thing.
Even worse. Here they are, harassing, abusing, and manipulating others, and committing many other crimes, in their quest to counterfeit orders.
The trial to have Dr. Catherine Killeen cross-examined, on May 2 and 3, 2012, never took place. Instead, On May 1, 2012, this crime ring collectively ran what is known as the child custody scam, detailed in the Carney letter to Cox, Dissecting Delusion presentation. 9 hours and 25 minutes of meticulously detailed frauds, crimes and abuses, which includes the meticulously detailing of their child custody scam. In short, they were never going to allow Dr. Killeen to be cross-examined. The reason so many crimes were committed, and the reason it took 5 months to get to that May 2nd and 3rd, 2012 time period, as it was originally scheduled for January 5, 2012. Crimes, which included Miss Sileski's first fraudulent criminal filing, accepted by Scott D. Schellenberger, where the main allegation was not even possible. Yet his charges state,
upon the facts contained in the application of Susan Sileski.
Facts, not allegations. Really. Besides it being from Miss Sileski, what happened to innocent until proven guilty? It should read, upon the fraud contained. This is dissected in another presentation, but if we look at the state's charging page only, things are more than obvious.
1. Violate ex parte/protective order. On or about January 17, 2012. Did fail to comply with an order of court dated November 23, 2011. Issued under the Annotated Code of Maryland, Family Law Article, Sector 4-506, that ordered the respondent to refrain from harassing Susan Sileski Stengel.
Note, that's the altered evidence trial, where Alison Meister Friedman was harassed and conned to commit perjury.
2. Computers illegal access. On or about August 1, 2011. Did intentionally, willfully, and without authorization, access computer services.
Dear Scott D. Schellenberger, besides this allegation, which you refer to as facts, is a. Not even possible. Miss Sileski swore in your filing, because her social security number was known, and her mother's maiden name, therefore, her Chase Bank credit card was hacked into. Besides the fact, any temporary information will only be sent via the email account on file, or text message to the phone number on file. Try recovering your own password, and see what happens. Apparently, you didn't bother spending the 5 minutes. B. It's 5½ months old, and estimated at that. C. Wouldn't your evidence, used to criminally charge someone with going to prison, given this relates to computers, have a specific date and time this crime occurred? D. Why is there nothing from any bank, or bank security department?
Well, that would be considered real evidence, and we don't bother with stuff like that.
E. Aren't you curious why she waited 5½ months?
3. Harris, A Course of Conduct. On or about August 1, 2011 to January 17, 2012. Did without a legal purpose, maliciously engage in a course of conduct that seriously annoyed Susan Sileski Stengel. With intent to harass, alarm, and annoy Susan Sileski Stengel, after warning to desist.
Dear Scott D. Schellenberger, do you have the warning to desist? Besides, any criminal will be annoyed by anyone reporting their crimes. Therefore, what this says is, any criminal can then file harassment charges against the person that reported it. And again, we have a 5½ month-old allegation. Excuse me, facts. Yet this one spans over the entire 5½ months. Besides, if this forms any sense of reality, what's the need for the first criminal charge on this list? Aren't you curious why she waited 5½ months, or what she was waiting for? Even if true, doesn't that time span alone says?
How serious can this be?
This was scheduled for March the 19th, 2012. However, Mr. Stengel was never served. So, he was served the day, in the courtroom. Miss Sileski and Mr. Carney were quite upset. Another missed prison opportunity. And since we are talking about harassment, and allegations equals confessions, what did Miss Sileski do that very night? At 10:05 p.m., Miss Sileski sends this Google invite to Mr. Stengel. Allegations equals confessions. Surprise! Besides. And Robert Wayne Lazaro, aka The Mole, after months go by, surrenders to a state agreement, committing crimes to cover up crimes. The details clearly show that included Judith ENSOR as well. In her own words, plays defense attorney for Dr. Catherine Killeen. after the child custody scam, began their supervised visitation scam. Even better, Mr. Carney assisted Miss Silisky in this criminal fraud game, and as a line item for it, in the divorce case. They all, including Judge Judith ENSOR, demands Mr. Stengel should pay. The Attorney Grievance Commission was also provided that, and was fine with crossing lines like that. Right, Glenn Grossman?
I went through the bills. I went through them line by line.
And, while in the area, although it's in all areas, we have more email driving.
Read 2 emails from Susie.
Then.
Read several emails from Susie.
Then below.
Read email from Susie.
And, what follows the driving? Correct the papering. Papering while. Driving while. Papering, says the line-by-line lady.
Draft letter to B. Lazaro.
Then.
March 14, 2012, B, G, C, draft email to Leon and Dr. Killeen.
Note, March the 14th, 2012. Dr. Killeen is still on the stand. Who can pass up the obvious? Well, not obvious for others, however, trained in Mr. Stengel's research, you would easily notice at the bottom, the driving has a reason.
Regarding her conversation with Maya about lying to her father.
Knowing the reality of the conversation, it's allegation equals confession. She is lying about lying. And, since the truth, or reality, is never good, redirect focus, and attack. Even if it's your own daughter. Besides, even if you did lie, when you were a child, didn't your mother tell everyone you were a liar? No. Well, then for sure not, your mother wasn't lying about your lying, and spreading it around.
I studied the descriptions.
And what follows the driving? Papering.
March 20, 2012, BGC, draft email to Dr. Killeen and Leon Berg.
Note, March the 20th, 2012, Dr. Killeen is still on the stand. And all for the discounted fraud billing price of $75. Very expensive paper. Besides, these two experts have a difficult time figuring out where the driving and papering is coming from. Apparently, they are blinded by all the dollar signs in their view.
The number of emails that people had to review.
Say it again.
The number of emails that people had to review. He is just papering to death.
FYI, in Mr. Carney's fraud bills, Mr. Carney's column alone has 479 lines that contain the word email. The 38 emails in one shot is on one line, which is also on the same line as Mr. Carney's own several email responses. Therefore the 2, 3, 6, 10, whatever email responses, along with the 38 emails, at most, count as one line. Multiple emails in each spreadsheet cell count as one. Therefore, there is little doubt, there are well over 1,500 emails, if not 2,000 or more. The email drivers were apparently driving 16-wheeler transport trucks, and Judge Judith ENSOR was supplying the fuel and insurance. Better yet, Mr. Bradford G.Y. Carney never provided Mr. Stengel with all of his fraud bills he demanded Mr. Stengel should pay. Therefore, these numbers are short. His bills are only reflected through the middle of 2012, yet Judge Judith ENSOR demands they be paid. Mr. Stengel can't question Mr. Carney's bills, nor can he see them all. The same is true for Leon W. Berg, as Mr. Stengel has yet to receive all of his fraud bills. Yet, Mr. Berg and Miss Silisky and Dr. Killeen demand payment, and the maximum 10% interest assigned by Judge Judith ENSOR. Demands made by committing more crimes in a federal courthouse. One would have to wonder, why would Mr. Berg spend well over $100,000 of his time in the last few years in order to obtain only $25,000? The answer? That's how trapped Mr. Berg is in Mr. Stengel's meticulous documentation of their many years of crimes against so many victims. Like them all, trapped rats. Where Mr. Berg in this real scenario is basically chewing off his own arm. Judge Judith ENSOR was representing Dr. Killeen, much like she was representing Miss Silisky in this.
can prove, see, but that's the difference.
That's where we are with this.
Right, but that's the difference. I have evidence and she doesn't.
I have a question for Dr. Kathleen Killy, Mr. Leon Berg, Mr. Bradford Carney, Mr. Robert Lazaro, Ms. Susan Selesky, Judge Judith ENSOR, Judge Kathleen Cox, and Scott Schellerberger. Mr. Stegall has over 2,000 compiled pieces of evidence, all hard-sourced. Most with many of your own words or actions. It doesn't get any more hard-sourced than that. My question to any, or all, preferably all of you is, can you provide just one of those alleged to have been done by Mr. Stegall, or even just one of any of your own allegations regarding Mr. Stegall? Just one will do. That would include the numerous protective order filings, gag order filings, motions, the motions to expedite the motions, and criminal filings, as well. As we all know, it's almost impossible to prove a negative, yet Mr. Stegall is able to do just that, over 2,000 times. Surely, between all of you, one should be an easy task. Off you go. If not, then each and every allegation made becomes a criminal act, and Scott Schellerberger and Governor Larry Hogan should be very interested in this case, especially since they primarily target minor children. Or does filing criminal charges only apply to whites that report the crimes, and the black community if they commit the crimes? But not the whites that commit the crimes, especially if there are nearly a dozen, and the number of crimes committed are well into the several hundreds. Is it because they commit so many crimes, to so many people, it's too much work? One last comment. If Mr. Lazaro and Mr. Carney agree Mr. Berg and Dr. Kelly's bills are fair and reasonable, and those very bills show it is all of them creating the bills, shouldn't they be paying the bills? That sounds more like fair and reasonable. What does Judge Judith ENSOR have to say about all of this?
And of course for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find the hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable. Fair and reasonable.
Fair and reasonable, really. Because each word could take many hours. For now, let's just go with this. It's both fair and reasonable for your crime ring to conspire and collude against Judge Martin, Mr. Stengel, his children, and others. It's both fair and reasonable for any witness, let alone Dr. Kathleen Killeen, an expert witness, to commit multiple crimes of collusion, conspiracy, racketeering, and more, while still on the stand, waiting for the case to continue, so she can be cross-examined. It's both fair and reasonable for Mr. Leon W. Berg, Bradford G.Y. Carney, Robert Wayne Lazaro, and even Miss Selesky, to collectively commit the crime of witness tampering. There is always more. However, with just these three offenses, Judge Judith ENSOR. Pick your poison. But, before you do, let's just confirm your knowledge of these criminal actions. For that, we allow Mr. Robert Wayne Lazaro speak on this very topic. On May 1, 2012, and in your courtroom. Mr. Lazaro, on page number 10 clarified.
May 1, 2012. Judge Judith ENSOR, presiding. Robert Lazaro. Bradford Carney. Leon W. Berg.
The only idea, if Your Honor, please, was that Judge Martin only heard Dr. Colleen's direct testimony. He then suspended the proceedings, advised Mr. Stengel to get an attorney so that she could be properly cross-examined. And that hasn't been revisited yet. So technically, Dr. Colleen is still on the stand.
Since December 1, 2011. 5 months and going.
Dr. Colleen is still on the stand. Dr. Colleen is still on the stand.
Pay no attention to, 5 months earlier, Mr. Lazaro's bills, documenting collusion, in the days prior to Dr. Colleen taking the stand, on December 1, 2011. November 29, 2011, Mr. Lazaro's bill notes.
Telephone conference with Leon Berg.
0.20 hours, $460. November 30, 2011, Mr. Lazaro's bill notes.
Telephone conference with Katie Killeen.
0.30 hours, $490. November 30, 2011, Mr. Lazaro's bill notes.
Telephone conference with Carney.
1.20 hours, for $360. November the 30th, 2011, Mr. Lazaro's bill notes.
Telephone conference with Dr. Killeen.
0.40 hours, for $120. AKA, the supervised visitation scam. We thank Mr. Lazaro for his confession. 1. He bailed out for the December 1, 2011, custody hearing. 2. Dr. Killeen was never cross-examined. 3. Yet that same December the 1st, 2011 day, after court, and while Dr. Killeen is obviously still on the stand, his own fraud bills shows a collusion meeting with Dr. Killeen and her husband, Dr. Paula Berman. December the 1st, 2011, after trial, Robert Wayne Lazaro's bill notes.
Meeting with Dr. Killeen and Dr. Berman.
0.50 hours, for $150. 4. Following that collusion, the next entry is to Dr. Devashkin, a psychiatrist. December the 1st, 2011, after trial, Robert Wayne Lazaro's bill notes.
Telephone conference with Dr. Phil Devashkin.
0.50 hours, for $150. Mr. Lazaro provided Mr. Stengel with 4 names for psychiatric help. 5. Proving, using his own bills, Mr. Lazaro acquiesced to Dr. Killeen's fraud instantly. 6. Also proving Mr. Lazaro and their crime ring had no intentions on cross-examining Dr. Killeen from the very beginning. Besides, how could she possibly answer to any of her sworn testimony? 7. After all, after Mr. Lazaro read Miss Zaleski's November the 15th, 2011, second fraudulent protective order filing, then, in regards to Miss Zaleski stated,
she is a psychopath.
8. Which also proves all of their fraud bills related to anything related to cross-examining Dr. Killeen was for knowledge of fraud and counterfeiting orders. 9. For further evidence of acquiescing to Dr. Killeen's fraud testimony, the next day, December the 2nd, 2011, notes a call to Dr. Hertzberg, another psychiatrist. December the 2nd, 2011, Robert Wayne Lazaro's bill notes.
Telephone conference with Dr. Hertzberg.
0.40 hours, for $120. This is further confirmed by Mr. Carney's bill, where he documents. Mr. Carney's bill also notes.
December 5, 2011, call from Elberg, regarding his conversation with Lazaro, who is not going to represent Mark. And revisions to PL order.
Billed 0.50 hours, for $187.50. Note, Mr. Lazaro bailed on December the 1st, 2011. And, although Mr. Lazaro did not represent Mr. Stengel for the PL pendente light hearing on December the 1st, 2011, and is not going to represent Mr. Stengel for the PL hearing rescheduled to cross-examine Dr. Killeen, Mr. Lazaro is involved in assisting in revising that court order. Mr. Carney's bill further notes.
Draft revised order, and letter to Judge Martin.
Therefore, they revised the court's order and sent it to Judge Martin, obviously, with the approval of all parties. And, 5 months after that, all the while, fraud billing Mr. Stengel for these very criminal acts. 10. Now, on May the 1st, 2012, just 1 day before Dr. Killeen was to be cross-examined, Mr. Lazaro confesses his knowledge of both. Dr. Killeen was never cross-examined, and Dr. Killeen is still on the stand. 11. However, just minutes before that confession, inside the courtroom, outside the courtroom, in the hallway, in order to circumvent the cross-examining of Dr. Killeen, Mr. Lazaro agreed to, scammed with, their consent order, telling Mr. Stengel it was temporary, maybe 2 weeks, and demands Mr. Stengel, who has not seen or even spoken to his children in 5 months, ever since Dr. Killeen's fraud parade, Mr. Lazaro tells Mr. Stengel about this order for the first time, and stated,
if you want to see your children, you must sign this.
Let's repeat that.
If you want to see your children, you must sign this.
12. This, known as the supervised visitation scam. 13. Obviously, what all their collusion, in the days leading up to the May the 2nd, 2012, and May the 3rd, 2012 trial, was all about. Mr. Robert Wayne Lazaro, this is correct, yes? Mr. Lazaro? Mr. Robert Wayne Lazaro?
Dr. Colleen is still on the stand.
Apparently, Mr. Lazaro was well aware of the facts and the law. Yet, Mr. Robert Wayne Lazaro had multiple communications with Dr. Catherine Killeen during those 5 months.
Go on. Show them the letter. You have so much more in the Killeen still on the stand folder.
Subject, Stengel. Date, February 18th, 2012, 4:09 p.m., from KW Killeen at BermanKilleen.com. To Bradford Carney, B. Carney at RMMR.com, Robert Lazaro at HWLLC.com. CC, Leon W. Berg, Legal Leon, at AOL.com, KW Killeen, at BermanKilleen.com, Richard Block, Richard at SBHPA.com. Gentlemen, my understanding is that, for some reason, the PL hearing will not resume. Rather, a hearing on the merits has been scheduled for May 2nd to the 4th. As you are aware, Mr. Stengel owes me a considerable amount of money, and I am not in a position to continue working, absent reimbursement for my time. I refer you to my letter to the parties dated December 28, 2011, with copies to counsel, wherein I state although I will appear in court on January 5, 2012, for the continuation of my cross-examination, I will resign from my position as custody evaluator, immediately upon conclusion of my testimony, absent payment in full of the outstanding balance. I am holding to the above. I will contact my counsel, Richard Block, this coming week to find out what I need to do to inform the court that I am no longer involved in the Stengel matter, nor am I available for expert testimony, and the many hours of preparation that will be required, absent payment of my bill in full, as well as a retainer to cover trial prep and testimony. I am happy to discuss this matter further, via phone conference if anyone wishes to arrange one. Please check with Sydney regarding my availability. Thank you. Katie. Catherine W. Killeen, Ph.D. 102 West Pennsylvania Avenue Suite 306. Towson, Maryland, 21204. KW Killeen at BermanKilleen.com. 410-337-8190. 410337-8192.
That will easily take several hours to view the dissecting. It was like watching an orgy. An alien orgy. Hold on, someone wants to say something.
Dr. Colleen is still on the stand. Dr. Colleen is still on the stand.
Before we forget, the email was sent on February the 18th, 2012.
Dr. Colleen is still on the stand.
Which referenced another illegal and unethical email Dr. Killeen confesses to sending on December the 28th, 2011.
Dr. Colleen is still on the stand.
He is the driving force behind this litigation. The number of emails that people had to review.
Dr. Colleen is still on the stand.
Mr. Lazaro sounds a little excited. For now, can you only point to a couple things in that email?
Okay. Just a couple, as this is being saved for the face-to-face show. Number 1, fraud. Number 2, papering, while
Dr. Colleen is still on the stand.
Number 3.
My understanding is that, for some reason, the PL hearing will not resume.
3A. Your understanding? Because our understanding is, you are a criminal. Besides, where did your understanding come from? 3B. The PL hearing is where you would be cross-examined. Therefore, months prior, your understanding was correct. 3C. What was the
some reason?
Well,
as you are aware, Mr. Stengel owes me a considerable amount of money, and I am not in a position to continue working, absent reimbursement for my time.
Number 4. Working. I believe the word is counterfeiting. Besides, that statement is false, as will be dissected later in this very presentation.
I refer you to my letter to the parties dated December 28, 2011, with copies to counsel, wherein I state although I will appear in court on January 5, 2012, for the continuation of my cross-examination, I will resign from my position as custody evaluator, immediately upon conclusion of my testimony, absent payment in full of the outstanding balance.
Number 5. Thank you for that confession. Number 6. However, on that date, you were already well aware, Mr. Lazaro, and your crime ring was scamming to postpone the January 5, 2012 hearing. Number 7. But a very nice try. Number 8. You will resign after that virtual hearing. If we assume your bullshit is not complete bullshit, why would you be needed after that? Number 9. Then, You state you will continue afterwards if you are paid. Number 10 again. Why would you be needed? Or should we get into your, for this school year scam you are famous for? Future fraud billing.
I will contact my counsel, Richard Block, this coming week to find out what I need to do to inform the court that I am no longer involved in the Stengel matter.
Number 11. Thank you for that confession. Number 12. There you go. Already informing the court you are not involved. Note, you will be involved for the rest of your life. However, Mr. Block probably advised you to wait, as that would make it too obvious. Number 13. And just to be sure, you're over 100 counts of fraud testimony is not questioned, you now demand a retainer, as well. Number 14. Reality. You will be subpoenaed, and you will be questioned. Number 15. 4 days. And not only by Mr. Stengel.
Nor am I available for expert testimony, and the many hours of preparation that will be required.
Number 16. The truth, with evidence, doesn't require much time. However, for you, your statement is correct. Many hours. Number 17. Don't bother preparing. You will be taking the fifth over and over and over. Besides, you may need a different attorney, as there are many questions for Mr. Block as well. He is receiving this email, correct?
I am happy to discuss this matter further, via phone conference if anyone wishes to arrange one.
Number 18. An open invitation to continue committing fraud. You are very kind to offer. And, in a collusion forum, as well. Number 19. For now, we only have one question. Just one. Did anyone, at any time, ever mention?
Dr. Colleen is still on the stand. 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 Dr. Colleen is still on the stand.
He is the driving force behind this litigation. And I'm telling you, I'm convinced there's other money as well. And he is the driving force behind this litigation. And I don't think he thinks he is.
And what about this? In the Circuit Court for Baltimore County. Consent Order, page number 1. It is this 22nd day of December. Page number 2 states,
5. Ordered that Dr. Kathleen Killey shall conduct a full custody evaluation in this matter. All costs shall be advanced by the plaintiff, subject to reapportionment by the court, and it is further. 6. Ordered that said custody evaluation shall include psychological evaluations of both parties in this matter.
That's pretty clear. Dr. Catherine Killeen, hired on January the 7th, 2011, for child custody evaluations and psychological evaluations on both parents. Let's take a look at what occurred, smack in the middle of Dr. Killeen's role in the process.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed. He is the driving force behind this litigation.
I'm just a gatherer of information. I'm just a gatherer of information.
And what about this? Mr. Carney's bill notes.
May 31, 2011, Research Criminal Law Statutes, Other Crimes Against Person, Surveillance. Study emails from client for use in petition for contempt, and motion for psychological evaluation.
Note, billed 1.10 hours, for $220. Surely that must be an error. After all, that is exactly what Dr. Catherine Killeen is doing, per the consent court order, dated December the 22nd, 2010.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed. He is the driving force behind this litigation.
And what about this? Mr. Carney's bill notes.
May 31, 2011, read through emails to prepare as exhibits, and draft motion for psychological evaluation.
Note, billed 2.80 hours, for $560. Again? What's going on here? Surely Enzo will see these.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed. He is the driving force behind this litigation.
And Mr. Stengel can do this. Mr. Carney's bill notes.
June 2, 2011, complete motion for psychological evaluation, with attached exhibits and order.
Note, although billed with other fraud, it's all fraud, therefore, billed 5.10 hours, for $1,020.
descriptions of the work performed. He is the driving force behind this litigation.
And what about this? Mr. Carney's bill notes.
June 15, 2011, revise and sign motion to shorten time and order, motion for payment of private school tuition and order, and motion to refer plaintiff for exam, by court psychiatrist.
Note, Mr. Carney himself is getting into the action, and billed 0.50 hours, for $187.50.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed. He is the driving force behind this litigation.
And what about this?
You know, I was upset because of all these things that were occurring to my children, right? So, that coupled with OCD, you know, I was just putting evidence together. That's what I was doing.
He is the driving force behind this litigation.
I'm just a gatherer of information.
And Mr. Stengel can do this. Mr. Carney's bill notes.
June 15, 2011, revise motion for psychological evaluation and order.
Note, billed 0.50 hours, for $100.
Mr. Lazaro, Mr. Robert Lazaro, come out wherever you are.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed. He is the driving force behind this litigation.
I was just putting evidence together.
He is the driving force behind this litigation.
And what about this? Mr. Carney's bill notes.
July 20, 2011, BGC, Reed L. Bergs, answers to motions to compel tuition payments, and psychiatric evaluation of Mark, and Dr. Killeen's affidavits.
Billed 0.40 hours, for $150. Note, it appears Mr. Leon W. Berg is teaming up with Mr. Carney, and provided or discussing Mr. Stengel, in regards to psychiatric evaluation. Also noted, is Dr. Killeen's affidavits, plural. Dr. Killeen, in the middle of her so-called impartial and independent psychological evaluation, provides affidavits against Mr. Stengel and his children.
He is the driving force behind this litigation.
I'm just a gatherer of information.
And what about this? Mr. Leon W. Berg's bill dated July 5, 2011, page number 1. Pay no attention to the yellow highlights and abuses to the schools, or Mr. Berg forwarding yet more things, playing hot potato, and especially not to the lower one, whereas Flowers is the counselor who Alex reported being beaten up by his mother, too. However, Mr. Leon W. Berg's bill notes.
June 21, 2011, preparation of response to defendant's motion, to have plaintiff referred to Office of Court Psychiatrist. 0.85 hours, for $255.
$255. Huh? With all of their conspiratory conversations, one may think Mr. Berg may at least mention to Mr. Carney, quietly, not to upset him, "What the hell are you doing?" Instead, prepares his response on June 21, 2011, then further discusses it with Mr. Carney, a month later, while further conspiring against his own minor clients.
I went through the bills. I went through them line by line.
And Mr. Stengel can do this. Mr. Leon W. Berg's bill notes.
June 27, 2011, preparation of affidavits for 2 motions, review and revise. Meet with Dr. Killeen. Telephone call with Dr. Killeen. 0.90 hours, for $270.
Note, although Dr. Killeen is in the middle of her so-called impartial evaluations, there is always time for an unethical break. In the Garrison Forest School fiasco presentation, you will learn, after them abusing Garrison Forest School, and Mile was kicked out, Mr. Stengel on September 8, 2011, requested from Dr. Killeen a mediator to get Maya back into school as soon as possible, which would have taken 2 to 3 days. On September 9, 2011, she responded,
Mr. Stengel, unfortunately, as an evaluator, I am unable to provide you with any suggestions or recommendation.
However, 2 months prior, she is able to sign affidavits supporting the best interest attorney regarding who should pay for private school. Surely Judith ENSOR would know this is not impartial, nor does Dr. Killeen's role have anything to do with finances and who pays for what. Again, that's only if we apply reality. Regardless, Mr. Stengel should pay the $270 in Mr. Berg's fraud bill, as Mr. Berg now represents Dr. Killeen as well. Dr. Killeen, due to her in the middle of her evaluations, unable to even provide a suggestion or recommendation to get Maya into school. Mr. Stengel was looking for a mediator. Miss Silisky and Mr. Carney quickly filed motions with the court, thereby forcing Maya to be out of school for weeks. Mr. Stengel, in an email to them all, Miss Silisky included, clearly documented, 3 things were more than obvious. 1. Mr. Stengel was the only one concerned for Alex and Maya. 2. Everyone else was never doing anything in the best interest of Alex and Maya. And 3. In fact, it was more than obvious, they were all, since the very beginning, intentionally doing what was in Alex and Maya's worst interest. Note, Maya was out of school for many weeks. Guess whose fault that was, via sworn testimony by Dr. Catherine Killeen? However, Dr. Killeen failed to mention the realities. Wait until you see those weeks of line-by-line items. This is the light version, compared to the insane and outrageous actions by them all during those weeks, and well documented in the Garrison Forest School fiasco presentation.
I went through the bills. I went through them line by line.
And Mr. Stengel can do this.
West's Annotated Code of Maryland. Criminal Law. Title 8. Fraud and Related Crimes. Subtitle 6. Counterfeiting and Related Crimes. Counterfeiting of orders for money or goods. Order for money or goods defined. A. In this section, order for money or goods means any writing, ordering, or requesting for the payment of money, or the delivery of goods. Prohibited. B. A person may not 1. With intent to defraud another, cause or procure to be counterfeited, or willingly aid or assist in counterfeiting an order for money or goods. 2. With intent to defraud another, issue, publish, or pass a counterfeit order for money or goods, if the person knows it was counterfeited. Or 3. Knowingly and fraudulently obtain money or goods, by means of a counterfeit order for money or goods. Penalty. C. A person who violates this section is guilty of a felony, and on conviction, is subject to imprisonment for not less than 2 years, and not exceeding 10 years.
He is the driving force behind this litigation, and I don't think he thinks he is. And that's one of the problems. I don't know if it's this diagnosed mental illness.
I'm just a gatherer of information.
And Mr. Stengel can do this. Mr. Leon W. Berg's Bill Notes.
June 13, 2011, review Mr. Stengel's email and 31 attachments. 0.30 hours, for $90.
0.30 hours. Apparently, an email and 31 attachments of evidence of abuses to the children, local, state and federal crimes, reviewed in only 18 minutes, went into the trash can. Therefore, the papering was trash paper. And the bills were not, from what Mr. Stengel provided.
He is the driving force behind this litigation.
And what about this?
5. Ordered that Dr. Kathleen Killeen shall conduct a full custody evaluation in this matter. All costs shall be advanced by the plaintiff, subject to reapportionment by the court, and it is further. 6. Ordered that said custody evaluation shall include psychological evaluations of both parties in this matter.
And Mr. Stengel can do this.
That order signed by Judge Judith ENSOR.
And what about this?
Number 16, ordered that neither party shall disparage the other parent in the presence of the minor children, nor shall they permit a third party to do so.
And Mr. Stengel can do this.
Today is February 4th, and spring is coming early because the groundhog didn't see a shadow and said spring is coming early. And the things have been the same. Dad trying to talk to Mom over like different things. They go out and talk to each other. But Mom's really mean because Dad's ringtone is Bad to the Bone. It's like, da-da-da. It's like weird. Bad to the bone, da-da-da-da-da. I'm just bad to the bone. It's weird. And that's what's been happening. I just got to Dad's, and today is Friday, so that's been happening in the past couple days.
Dr. Alan Kimmel, Ms. Steggall's medical doctor, aware of Ms. Steggall's mental health issues.
I don't know if it's this diagnosed mental illness.
And what about this? Dr. Killeen began on January the 7th, 2011, and provided her sworn expert testimony as Mr. Berg's only called witness on December the 1st, 2011, nearly 11 months later. 3 months after Mr. Stengel provided the information, and 4.5 months after Dr. Killeen began, comes May the 19th, 2011, as noted by the black line. Dr. Killeen's bill notes,
May 19th, 2011. Telephone call with Dr. Kimmel. 0.50 hours, for $125.
Apparently, Dr. Killeen verified what Mr. Stengel provided was accurate. Upon Mr. Stengel contacting Dr. Kimmel's office, he was told, no records were requested.
And of course for that, I only have the pleadings filed and instructions delineated in the bills themselves.
What about the medical files, which were apparently billed for, yet never obtained?
Dr. Alan Kimmel, Ms. Steggall's medical doctor, aware of Ms. Steggall's mental health issues.
Fair and reasonable. I only have the pleadings filed and instructions delineated in the bills themselves.
And Mr. Stengel can do this. What about the medical files showing Dr. Killeen can't do basic math?
I only have the pleadings filed and instructions delineated in the bills themselves.
And Mr. Stengel can do this. Dr. Killeen's bill notes,
May 19th, 2011. Telephone call with Dr. Jonas. 0.30 hours, for $75.
What about the non-requested medical files showing Dr. Killeen falsely opined for other professionals?
I only have the pleadings filed and instructions delineated in the bills themselves.
What about the manufactured custody battle Dr. Killeen mentioned to Dr. Jonas?
Fair and reasonable.
What about Dr. Killeen's refusal to contact Dr. Malika? You, Judge Judith ENSOR, received Dr. Malika's report from Mr. Stengel. What about this report?
And of course for that, I only have the pleadings filed and instructions delineated in the bills themselves.
Of course. What about Mr. Stengel's prescriptions lists, also provided to you, Judge Judith ENSOR? You received them from Mr. Stengel as well, correct?
I only have the pleadings filed and instructions delineated in the bills themselves. I only have the pleadings filed and instructions delineated in the bills themselves.
Bottom line, when Dr. Catherine Killeen provided sworn testimony under oath and the penalty of perjury, suborned by Leon W. Berg, Mr. Stengel was not being prescribed any of those medications whatsoever. And the very reason Dr. Malika's orange bar falls short of the red line. No contact, or any attempt to contact Dr. Malika whatsoever. And yes, Mr. Stengel provided Judge Judith ENSOR with all of that, and loads more. And always, always remember. And Mr. Stengel can do this. In response to Mr. Stengel's complaint to the Attorney Grievance Commission, 1.5 years later, knowingly lies, stating,
B. Dr. Killeen was not only concerned with plaintiff's pharmacological issues. Dr. Killeen stated, at the December 1, 2011 hearing, that plaintiff had notable personality issues.
Note, Mr. Berg refuses to answer the allegations, and does what class? Redirect focus, and attack. And, with complete bullshit, also provided these lies to the Commission, with evidence Mr. Berg is or are, he knowingly suborned these lies on December the 1st, 2011, and repeats it to the Commission. Besides,
the number of emails that people had to review. Under what, 400 emails? I only have the pleadings filed and instructions delineated in the bills themselves. The number of emails that people had to review.
Mr. Stengel will tell you that he said
defense number 36, is it? Joe, go get that binder off my couch, please. The number of emails that people had to review.
What happened to Joe?
What happened to Joe?
What happened to Joe? So then what happened to Joe?
I only have the pleadings filed and the descriptions delineated in the bills themselves. I only have the
Mr. Stengel will tell you that he said
defense number 36, is it? Joe, go get that binder off my couch, please. I only have the Mr. Stengel is the kind of person that I would have to be very careful with my words.
A lot of people give it by itself when there is pain. But Ambien is a very dangerous drug.
From Susie Stengel, susiestengel@me.com. Sent, Friday, October the 22nd, 2010, at 11:51 p.m. To Mark Stengel. Subject:
Good night. Just took one of Aunt Janet's Ambiens. Headed to sleep. Love. Me. Susie Stengel. Creative Memories Senior Consultant.
But Ambien is a very dangerous drug. Because I think there's a lot of evidence that right now his judgment is very poor, and I do believe that at least in part is due to prescription medication.
Does that represent one of the reasons for your position on custody as well as access?
Yes, absolutely. It's one of the heart.
As we look at the real evidence, opposed to the evidence in Dr. Killeen's non-provided, contractually obligated report for outside third-party review, is it really the heart of the issue? Really? Then confirms Judge Martin, asking if that relates to both custody and child access.
Yes, absolutely. Yes, absolutely. Yes, absolutely.
Although Mr. Stengel is prescribed zero medication, at this point, let's listen to Dr. Killeen provide her expert opinion regarding how bad things are in regards to Mr. Stengel and his drug problem.
Many of the things that he says, and at times says to other people, he's really doing some distortion. And he has this huge investment. He's got a campaign going on, and he's got a huge investment in it. And I think that getting the medication situation cleaned up will help, but I think he's going to need to be in treatment. And I really think it has to be a team approach.
So, what does that all mean? Well, still on page number 34, let's listen. This sworn testimony on page number 34 relates to Mr. Stengel, the drug addict, being such a danger, he requires therapeutic supervision. But really the alienation game. We will listen to the key portion for this fraud exhibit. Such a danger, the children should not be able to be with Mr. Stengel overnight. We will listen to it twice, so it sinks in.
That person should also have open communication with the person that's doing the supervised visitation. Because I think these kids are severely at risk. Severely. That person should also have open communication with the person that's doing the supervised visitation. Because I think these kids are severely at risk. Severely.
Severely at risk. Severely. One might wonder exactly how severely at risk are the children with Mr. Stengel. For that, we only need to go to Dr. Killeen's own contract.
4. There are some situations in which I am legally obligated to release information and take action to protect others from harm, even if I have to reveal information that I obtained during the evaluation. For example, if I believe that a child or vulnerable adult is being physically or emotionally abused, I must file a report with the appropriate state agency. Furthermore, if I believe that you are threatening serious bodily harm to another, I am required to take protective actions. These actions may include notifying the potential victim, contacting the police, seeking hospitalization, and/or developing some other protective plan. If you threaten to harm yourself, I may be obligated to seek hospitalization.
I think these kids are severely at risk. Severely.
Given they both can't be truthful, what does Judge Judith ENSOR have to say in these regards?
I went through the bills. I went through them line by line. I studied the descriptions of the work performed. They're reasonable.
Well then, let's try this.
I went through the bills. I went through them line by line. I studied the descriptions of the work performed.
Perfect. Now, we are getting to the meat of your line-by-line statement. So, where in any of your crime rings bills does even one line reflect?
I think these kids are severely at risk. Severely.
Well then, can you provide one line item in Dr. Killeen's bills or Leon W. Berg's bills that reflects anything sworn to by Dr. Catherine Killeen? There are many to choose from. Just one.
Mr. Stengel is the kind of person that I would have to be very careful with my words. He is the driving force behind this litigation.
And what about this?
This is one of those tricky things, and perhaps someone else will see it differently, but I am telling you, Mr. Stengel keeps coming up with money. Now, I can't tell you exactly where it is. I really can't. I can't point to an exhibit that says exactly where it is.
Evidence? Evidence is not necessary. After all, this is a magic show. Not exactly where it is. How about generally? Can you point to where it generally may be? How about remotely? Have you looked in your crime ring's bank accounts? Mr. Stengel provided you with well over $200,000 of documented stolen money by Miss Silisky. Have you looked at Miss Silisky? Well,
this is one of those tricky things, and perhaps someone else will see it differently, but I am telling you, Mr. Stengel keeps coming up with money. Now, I can't tell you exactly where it is. I really can't. I can't point to an exhibit that says exactly where it is.
Mr. Stengel has money. Really? And you are sure? Yet, Mr. Stengel says that's not true. You continue your rant on page number 195. And you use the word convinced. Given not one of you were ever able to provide evidence, Mr. Stengel even lied one time. That's a very strange statement. Because that could only be possible if you were somehow involved in yet more criminal activity with your crime ring, which would be unbeknownst to Mr. Stengel. Otherwise, how can you be convinced?
And of course for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I do find the hourly rates charged to be fair. I find the time allotted for the tasks performed reasonable. Line by line. 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 Line by line.
Almost forgot.
Line by line. Line by line.
There is one thing everyone can be very sure about. It will be much less work if Judge Judith ENSOR can show any line whatsoever in any of their bills whatsoever that cannot be traced to fraud. In fact, soaked in fraud. And, to make it even easier, we will include the fraud be with their collective foreknowledge they were in fact committing a crime with every line. In fact, rather than
line by line,
what we have is crime by line.
Catherine W. Killeen, Ph.D., Towson, Maryland, 21204. Provisions for accepting an invitation to serve as an impartial expert in custody/visitation litigation. I make every reasonable attempt to serve the court as an impartial expert, rather than as an advocate, in custody litigation. In order to serve optimally in this capacity, I must be free to avail myself of any and all information, from any source, that I consider pertinent and reasonable. In this way, I can best serve the interests of children and parents involved in such conflicts.
He is the driving force behind this litigation.
And what about this?
Because as Mr. Fetter said, to ferret out the lie, you've got to do more work. And the more work I did, the more frustrating it became because I just kept coming up empty.
He is the driving force behind this litigation.
And what about this?
Most of the 36 years that you've been a lawyer, and I think all of the 35 years that I've been a lawyer. And have I been known as a person who tries cases on a regular basis as opposed to a person who settles cases or files motions and then settles cases for the most part? Yes.
And his own expert confirms it. I believe we located the driver. Hold on. We are trying to get a positive ID. 1 second. Here we go. Oops. That's not an ID. That's a DUI. 1 second. More information on this driver is coming across the wire. Your patience is appreciated. Okay, apparently, he is not a lone driver. He needs assistance. He would like to explain one of the reasons why.
Do I need to get you some Tylenol or something, Mr. Crown?
I'm sorry, Your Honor, I'm loaded up on Valium and Oxycontin. It's really good stuff. It's great. It doesn't work. That's what I'm taking.
I only have the pleadings filed and the descriptions delineated in the bills themselves. I only have the
Even though Mr. Carney confesses, he is the driver and is known for that. And his own expert confirms it, knowing him for decades. What does Judith ENSOR know about that? What does she personally know? Always remember. Which can be confirmed by this case. Not just any case. Hell no. This case connects Judith ENSOR with Bradford G.Y. Carney. Follow along this slime trail. 1. ENSOR represented SCAMS prior to becoming a judge. 2. Upon becoming a judge, ENSOR hands her case, SCAMS, to Bradford G.Y. Carney. 3. Curiously, not to someone in the law firm where she was working. 4. Of all people on this planet, Bradford G.Y. Carney. 5. As you heard, he himself basically said, he is known as a slime ball lawyer. 6. His expert witness confirms in so many words, he does what is known to the public as a slime ball lawyer. 7. Now, this gets really interesting. 8. ENSOR hands her son this case to Carney, as noted, in settlement stage. 8a. Let's repeat that. In settlement stage. 9. Who wants to guess what Mr. Bradford G.Y. Carney does? 10. Not wanting to tarnish his reputation. Settlement? Hell no. 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 11. Long story short, SCAMS winds up suing Bradford G.Y. Carney. 12. And for the frosting on this fraud cake. That lawsuit is going on at the same time as Judith ENSOR is presiding over the Stengel case, which Mr. Carney is involved. 13. Adding some sprinkles to this fraud cake. Judith ENSOR never discloses this conflict of occurrences. In summary, ENSOR hands Carney a case where Carney winds up getting sued by the client, SCAMS, who originally was ENSOR's client. That lawsuit is occurring during the same times period. For now, remember 5 things. Number 1, 2% of what is documented in the Stengel case makes it all more than obvious. 2 plus 2 equals anything but 4. Number 2, besides what you hear coming out of the extremely psychotic ENSOR's brain, she has her own personal experience with this exact same fraud and going on at the very same time. That doesn't include Mr. Carney confessing he is known for these actions. Number 3, Mr. Stengel's lab rats, all of them, do not possess a conscience. They are literally dead on the inside. Your conscience is what provides your humanity. Therefore, what you have is a machine. The extreme ones are identical machines. Like Donald Trump, you will never get actual evidence. Just redirecting the focus with roundabout nonsense. And they cannot control it. That's the beauty with Mr. Stengel's research. They keep proving Mr. Stengel's research is spot on. With no controls, they keep repeating the same actions. For example, Donald Trump is an extremely high-level unconscionable. That comes with a 100% guarantee. You may listen to Donald Trump and think he doesn't answer the question, or he lies, or flies off the handle, or he files bankruptcy many times, or whatever you may think. However, once you better understand Mr. Stengel's research, you will better understand what you are looking at and listening to. At which time, all those other thoughts are not only pointless, but a waste of time. Why? Because it's all obvious. Who talks about the obvious? What's the point? If you were to pay attention to only one thing, it is this. All the actions or allegations regarding Donald Trump and his responses to them all, regardless of the level these actions may be, they all have one commonality. Not one of them bother him. Just notice that. They do not bother him one bit. Besides, these types only care about themselves. That's not a choice. It's just the way it is. Not even his own children, let alone others. He simply can't feel anything. and the same reason, no matter what he does, will not bother him. Add to that, like them all, he will say whatever he needs to say at that very moment to get whatever he wants at that very moment. Therefore he himself has no idea what he might say next. If one considers voting Donald Trump as president, one should understand you are voting to put a hand grenade in the Oval Office. A hand grenade that itself has no idea when it will go off, where it will go off, or how many times it will go off. When you look at Donald Trump, or any of these extremely high-level unconscionables, from a view not of who they are, rather, what they are, you will begin to notice the repeated actions. You just need to know what to look and listen for. Mr. Stengel's research has some very nice tools to assist the average person, which is the common thread they all have in their hatred for Mr. Stengel. Wrongfully incarcerate him. Illegally remove his First Amendment rights. Fraudulent gag orders. Intentionally involve and abuse so many as their protectors, of course. If you ask any of them what they are being protected from, you will get a blank look. That's because, in regards to Mr. Stengel, they personally never had any problems. And they're used to being told what to do. All of these crimes and abuses have to do with the same thing, and why they are all on the same team. Prevent Mr. Stengel from providing anything regarding the divorce. His research is countless years beyond the psychology industry, as you will see for yourself how many psychologists themselves are conned by these types, and just related to this case. All well documented. They don't care about the divorce, rather what Mr. Stengel discovered within the so-called divorce. The divorce is his research. His research contains his research subjects. His research is not like any other research, which mostly contains theories. Mr. Stengel's research comes with tools. Tools for the average person, even if already involved with these types. Tools for prevention. Prevention for the average person. Prevention. A word that does not exist in the psychology field. Evidenced by the many school and theater shootings, for example. When they occur, when have you ever seen someone in the psychology field come on TV to explain why? What you will see are the parents all saying the same exact thing. I didn't know. Unfortunately, they are telling the truth. People want to blame the parents, saying they should pay attention. Pay attention to what? Johnny did this, or Johnny did that. Kids are different. Your own kids are different. After a while, almost everything becomes normal. That's Johnny. Besides, how can you blame anyone that doesn't know? Or you will hear, they should have known. How should they know, when the psychology field itself hasn't a clue? If that industry did, they would be on the television explaining it, especially at those times. At a minimum, one would think, where is Dr. Phil? The only advantage Dr. Phil has over the average person is this. Dr. Phil knows that he doesn't know where the average person hasn't a clue of its existence. Dr. Phil will say what the industry will say. Well, we have to give them tests. That alone confirms the non-existence of prevention in the industry. In fact, those in the psychology field themselves are taken in, conned and manipulated by these types, time and time again. Which leaves some questions. How are they going to help you? How could it be the fault of those parents? The other question is, why don't those in the field themselves know, and themselves conned and manipulated by these types? Even the brilliant ones, directly related to this issue. Why? Mr. Stengel believes a conscience trumps everything. A conscience is not something that comes and goes. It's 24/7. Just like your brain. It's not possible to stop your brain. Try it. Good luck. The difference is, your conscience works the same way. However, more in the background. Although in the background, it controls your brain, and which direction thought patterns will look at, think about, act upon. This all occurs on the fly, without you aware it's actually happening. This redirect is happening on the fly, without your brain even aware. Therefore, your brain doesn't really get a say in the matter. Therefore, whether you're in the psychology industry or not, whether you are brilliant or not, everyone faces the same exact dilemma. These tools create recognition. These tools also act as a magnet. A magnet that puts your brain in the game. Mr. Stengel asks only 2 questions. And if you know anyone having been involved with these types, you can ask them as well. 1. What would it have been worth if you knew in advance? 2. How different would your life have been? Everyone can ask themselves a question. What would it be worth if you could better understand who your children are choosing as friends? Or better yet, who your kid may be wanting to marry? However, these tools are not for parents, rather everyone, including your children. Not the young ones, the adult ones. Got all of that? Good. Before we move on, these types will not be very interested in watching, listening, or reading this for too long. It will be very painful to them. Like reading an autobiography of hell. Back to the research subjects and their contributions to society. Why are they determined to stop Mr. Stengel, and collectively so? Because Mr. Stengel has blown up their world, so to speak. Not only did Mr. Stengel discover this group in society, he is exposing a closet that society as a whole are completely unaware of. Introducing a closet to society. Not just any closet, rather the largest closet of all. To make matters even worse for them, he devised tools. Tools, with some, where simply by observing and knowing what to look and listen for, they will basically expose themselves. For example, Mr. Stengel is providing research and discovery of an unknown group in society, even unknown to their own children, friends and spouses, or significant others. A group that does not possess a conscience, therefore can easily prey on children, the public, even their own children. Discovery, which comes with tools, with very strict instructions, and should never be used to even come close to jumping the gun, so to speak. However, allowing anyone, over time, with proper verification, and lots of it, to realize they may actually be sleeping with the enemy. Tools to expose predators. Even includes a tool that can be used in regards to this very writing. Someone, anyone, has a problem with this research. Because this is just information. It's not forced upon anyone. Use it, or not. Why would anyone have a problem with hearing about predators and their ways? Therefore, in this tool scenario, those with a problem are simply exposing themselves. How is that, for a tool? Tools, which leave them no way out. Leaves them with but one option, and one option only. Kill the messenger. One way is by discrediting Mr. Stengel. He is crazy. Mentally ill. Can't listen to or believe anything he says. So devastated is this group, we only need to look at the extremes they have all gone to, and must continue to go to, forever. Extremes, which a conscience would prevent even one action, let alone hundreds. Extremes, such as false incarceration. Smear campaign, after smear campaign, after smear campaign. Fraudulent gag orders. Illegally removing Mr. Stengel's First Amendment rights. And even not inviting him to defend those rights. Brainwashing people to remove their own rights to be informed. The alienation game. As if Mr. Stengel's words come with deadly explosives. As if his mailings had deadly explosives. Conning schools, teachers, children, and whomever. Using people's names without their knowledge. Identity theft, and identity fraud. Mr. Berg lying to federal agents, trying to have Mr. Stengel federally prosecuted and incarcerated. As if that could in any way be in the children's best interest. Such that they had a U.S. postal agent staking out Mr. Stengel's home and was caught by his older son. Stake out his home because Mr. Stengel is such a dangerous person. Dangerous, yes. But not to those they claim they are protecting from Mr. Stengel. Dangerous, to them. Everyone else are just pawns. Pawns used to protect them. The extreme opposite to what they tell everyone and claim in order to con so many. Like the federal agent staking out Mr. Stengel's home. Lying to federal agents. No problem. Mr. Berg only cares about Mr. Berg. Mr. Berg's own daughter or wife have no idea what he is. Not who he is, rather what he is. An unconscionable. Forget about the public. How devastating is that for Mr. Berg? Mr. Stengel coined many phrases. In essence, creating funnels for what otherwise is splintered and all over the place. Therefore the separated pieces don't ever come together, leaving everyone clueless. These predators like that very much. However, there are many phrases created, making it easier to see it for what it really is. Such as the alienation game, or the unconscionables, and many others. Like allegations equals confessions, which is incredible value. The psychology field uses the word projection. Forget about the projection concept. It's actually counterproductive. With the same exact scene, one will have you angry and combative. The other will have you calm and being informed. So sit back, relax, listen, learn, and enjoy the show. Besides, they are not going to admit to wrongdoing anyway. It's more than obvious with all the mentally ill mentioned. It's actually nice to hear them talk about their innermost secrets. Remember, with a conscience, none of their actions bother them. They can't feel. They can think what you think, but can't feel what you feel. They use your conscience against you. And those very actions have one with the conscience saying, no way. And the very reason, in the Timeline series number 1, episode number 1, is titled, No Way. Yay way. We have 1. Judge Judith ENSOR, falsely accusing Mr. Stengel of driving the litigation. 2. Bradford G.Y. Carney confessing, that's what he is known for, and for decades. 3. Mr. Carney's own expert, having known Mr. Carney for decades, confirms he does not settle cases, rather drives litigation. 4. Their fraud bills, showing collusion, in dozens of entries. 5. Even the collusion lunch meeting with Bradford Carney and Leon W. Berg. 6. Mr. Carney ringing up, and obviously manufacturing bills. 7. A billing entry, related to Miss Zaleski's first fraudulent criminal filing, yet noted in the divorce case billing. 8. Judge Judith ENSOR, falsely accuses Mr. Stengel of driving the litigation, by sending many emails, yet Miss Zaleski sent 38 emails, in one shot. However, a review of Mr. Carney's initial bill, and only 13 days since he was retained, shows 9. Miss Zaleski sending another 22 emails, totaling 60 emails, sent by Miss Zaleski, in just the first 13 days. Making it more than obvious, the driver, or drivers, if one were to go line by line, just in Mr. Carney's first invoice. If we go back to page number 2, apparently Mr. Stengel is also responsible for Dr. Killeen's unethical act, by speaking with Miss Zaleski, prior to signing on to the case. Mr. Carney's bill notes.
December 28, 2010, call from Susie regarding her conversation with Dr. K. Killeen, 0.30 hours for $112.50.
Yet Dr. Killeen fails to note, or mention this. And, Mr. Stengel, can do this.
Methodology that I used in this case is standard acceptable methodology when one is conducting a custody evaluation. And the guidelines of the American Psychological Association, I interviewed the parties initially together because I wanted to hear for the first time what each of them has to say without either one of them feeling that I've already been biased in some sort of way.
Really?
Page number 3. My experience has been that conducting the evaluation in the manner described above provides me with the optimum conditions for providing the court with a thorough and objective recommendation.
Really? American Psychological Association. Dear Arthur C. Evans, C.E.O., apparently, Dr. Catherine Killeen, from Towson, Maryland, USA, is a spokesperson, and represents the guidelines of the American Psychological Association and its members. Can you direct us to the specific American Psychological Association guideline, which relates to what was just witnessed? Or anything we have witnessed, thus far? Yet, just the tip. 10. Numerous billing entries for preparing and filing with the court for psych evaluation for Mr. Stengel during the time Dr. Catherine Killeen was hired to do exactly that, and hired by consent order, which Mr. Carney and Miss Zaleski agreed. 11. The court responded, the entire filing was moot, or pointless, due to Dr. Killeen is doing just that. Obvious intentional fraud. 12. Bills were also generated by Leon W. Berg, who did not say anything, yet responded with his own response to that ridiculous motion. Really, Mr. Berg? 13 bills were also generated by Mr. Lazaro, having two, should we say, wanting to respond to that motion. 14 Judge Judith ENSOR herself signed that very consent order. 15 we have Judge Judith ENSOR hands over her own case to Mr. Carney upon becoming a judge, which goes from settlement stage, which she herself had that case in, prior to handing it to Mr. Bradford G.Y. Carney, which then goes into chaos mode. Surprise! 16 Mr. Carney is then sued by that very client. 17 that lawsuit is going on at the same time frame as the Stengel case, Judge Judith ENSOR is presiding over. 18 Judge Judith ENSOR fails to disclose this information. 19 and Judge ENSOR accuses Mr. Stengel of things, while confessing she has no evidence, but she is sure. And it's Mr. Stengel's doing, due to his mental illness. Mental illness, which Dr. Killeen swore to under oath on December 1, 2011. Apparently, Mr. Stengel documenting evidence somehow causes litigation. That in itself is a twisted mystery. Besides, the amount documented goes towards the insane amount of wrongdoings by these very people, which as you can see, includes ENSOR. Before we continue with more driving lessons, and while on the topic of mental illness, here is a bit of history. We will read from a transcript dated August 27, 2014. A contempt hearing against Mr. Stengel, of course. It should be noted, Miss Silisky was in violation of the consent order no less than 100 times. One time she kept Mr. Stengel's daughter overnight on a night she was to be with Mr. Stengel. Mr. Lazaro not only refused to bring contempt charges, but refused to even write a letter. With all that said, Mr. Stengel was falsely incarcerated in April 2014, and the state demanded he be psychologically evaluated by a psychiatrist chosen by the state. The tests were performed on June 9, 2014. On August 14, 2014, the state of Maryland's ordered results came back, and completely conflicted with Dr. Catherine Killeen's results, as she swore to under oath, and the penalty of perjury, on December 1, 2011, and suborned by Leon W. Berg. The results further stated, Mr. Stengel's allegations of corruption, by attorneys, and the judge, has merit. That was not good for this crime ring. Okay, now we pick up on mental illness, and on August 27, 2014, at the contempt hearing, and just 2 weeks after, the results.
Mr. Stengel is the kind of person that I would have to be very careful with my words.
Noting, it's on the beginning of page number 65. Say it again.
Mr. Stengel is the kind of person that I would have to be very careful with my words. He posted about the divorce, and by that I mean his unhappiness with the expert's opinion, with Mr. Berg's activities, with Mr. Carney. I mean, absent the divorce proceeding, Mr. Berg would have no connection with these children. None. It's only because of the divorce. So his postings arise out of the divorce. He was not to post anything about the divorce, and he chose to do so. Now, there's been this undercurrent this morning about psychological evaluation with respect to a criminal case. I wasn't provided with a copy of that. I'm not asking to see a copy of it. There are no doubt mental health issues involved. There are no doubt mental health issues involved. There are no doubt mental health issues involved. He testified that Mr. Stengel was spending up to 6 hours a day chronicling what he thought were Ms. Zaleski's discretions and indiscretions. I am obviously not a mental health expert, and not even an expert. I'm not involved. But I'm telling you, I know the man's mentally ill, because I heard what the doctor testified, and I don't even remember, Mr. Rudo, if you were involved in the case at that time, but the defense that was brewing to Mr. Stengel's completely inappropriate behavior was, please don't hold me accountable, because I've been diagnosed with obsessive compulsive disorder. That was brewing. It never really came to be, but what I will tell you is this: I don't have a shred of evidence before me. Well, let me back up. Dr. Lyon testified that Mr. Stengel's been diagnosed with schizophrenia and compulsive disorder.
We could literally spend hours dissecting what we just heard, however we will touch on a couple. 1. Obviously, she does not take her own advice, regarding being careful about her words. Fact, she can't. She does not possess the controls. Therefore, she herself has no idea what she is going to say next. That's due to something called reality. These types will say whatever they need to say at that very moment to get or obtain what they want at that very moment. 2. They all keep tying their frauds and crimes to a divorce to obtain fraudulent gag orders, using some divorce as their shield for crimes. If not for 0 degrees to reality, she will be correct. In fact, the divorce is long over, yet they still play that fraud game. 3. She says, absent the divorce proceedings, Mr. Berg would have no connection. Basically saying, therefore, Mr. Berg is attached to the divorce. Question for the extremely psychotic judge, this Judith ENSOR. When is a crime not a crime? 4. She says there is this undercurrent about a psych evaluation in criminal case. She is not interested in seeing that. Fact, that tells us the queen of ex parte communications already knows what it says. Besides, Dr. ENSOR is sure of mental health issues. Unlike when she has no evidence and can't point to anything and is sure. Here, there is opposing evidence, and she is sure of the complete opposite. Reality, her own words, are samples of a severely, mentally deranged mind, overflowing. 5. Chronicling what he thought were Miss Zaleski's indiscretions. Yet 11 months earlier, she herself states Miss Zaleski lies to police, files false financials. 6. Not a mental health expert. Yet, she will speak as one. And she is sure, once again. Note, we will come back to this one for good reason. 7. She is not sure if Mr. Rudo was involved in the case when they were running Mr. Lazaro and his crime rings mentally ill scam. That one, she is not sure of. 8. Brewing, but nothing became of that. Rid of Lazaro, and it's magic. Get rid of their mentally ill scams. However, you will notice, ENSOR is now, and has been, carrying it for the crime ring, ever since. 9. However, ENSOR does confess, Mr. Stengel's meticulously documenting the crime ring's criminal activities is inappropriate behavior. 10. And schizophrenia. Besides, her literally just manufacturing it on the spot, and allegations equals confessions, it is believed that was one of the things that had ENSOR warned by the Commission on Judicial Disabilities. Then recused from Mr. Stengel's cases. And Mr. Stengel should do this.
Number 16, ordered that neither party, nor Justice Judith ENSOR, shall disparage the other parent, in the presence of the minor children, nor shall they permit a third party to do so.
We will go back to number 6, as it is one of Mr. Stengel's tools, and one to remember. It ties other things together as well. Just using a few examples. 1. They contradict themselves. 2. They have no idea what they are going to say next. And as you will hear, from a few words to a few word. 3. The extremely high-level ones are simply machines that repeat the same actions. We will provide 3 different situations with the identically same actions. First will be listen to Judge this Judith ENSOR again. Then, we will read from one of Mr. Leon W. Berg's responses to the Attorney Oversight Commission. And finally, we will read what Miss Zaleski told a police officer, noted in his report. We start with ENSOR. She stated,
I am obviously not a mental health expert, and not even an expert. I'm not involved. But I'm telling you, I know the man's mentally ill.
As best interest attorney, I made no findings. As between the parties, there was no doubt in my mind that the matters of concern regarding Mr. Stengel as voiced by Dr. Killeen were far more compelling than any concerns about Miss Zaleski. Interviewee Susan Stengel advised that
when she found it, she questioned Maya Stengel, who refused to comment.
She stated that
Maya Stengel told her
same exact actions, yet 3 completely different backgrounds. Learning to remove the backgrounds provides the ability to focus on the actions, which in turn allows for recognition of repeated actions or offenses. Consolidating realities creates patterns and makes all the difference in the world. It may not appear so important, but it's very important. A school shooting, and the parents of the shooter or shooters will say they didn't know. However, the information or signs are flying by more often than one would think. It just doesn't look the same, therefore, you see no pattern. A drug epidemic can and will be devastating. Your child was one of the unfortunate who lost their life. There are, and have been, signs. Their friends have been providing signs. There is no package that will be delivered. You have to put it together. It's not as hard as one would think. Keep in mind, actions are repeated, such as,
he is the driving force behind this litigation.
Before we leave the consent order and contempt area, let's see where we can combine those two, with abusing the schools, lots of people, and these three statements.
He is the driving force behind this litigation. The number of emails that people had to review, he is just papering to death.
As noted, Miss Siliski was in violation, therefore in contempt of the consent order, no less than 100 times. We are familiar with number 16. So what goodies does number 15 have for everyone?
Number 15, ordered that neither party shall send emails, nor any other written communication, regarding this divorce proceeding, or any other ancillary issue, to any third party not related to the litigation, except through counsel.
With over 100, we will look at only 2. Although the order was agreed to, and signed on December the 22nd, 2010, Miss Siliski was in contempt, within 18 hours. The very day after, the December 22nd, 2010, consent order, Miss Siliski is already in contempt of that order. Things of interest: 1. The day after, Miss Siliski and Bradford Carney, along with the consent order, filed her first sworn zero income statement. The email is from anivators.com. 2. Email blasted out to many. Sent Thursday, December the 23rd, 2010, at 9:26 a.m. The email repeatedly disparages Mr. Stengel. This is only the top portion. As you will see next, in another Allegations equals Confessions Act, Miss Siliski states,
This is my secure email address, so please do not share this information, or email address, with anyone else, or forward in any way.
Translated, do not do what she does to you and everyone else. From Susie S. onaverdefrance@gmail.com. Sent Saturday, April the 9th, 2011, 9:05 a.m. to nearly 80 victims listed in abusive violation of the court orders.
I am closing this email account effective today, for reasons that disturb me greatly. However, I continue to receive emails from someone in my life that I do not wish to receive emails from, which are abusive and harassing in nature.
Note, the yellow highlighted are to Boys Latin and Garrison Forest schools. Although Garrison Forest School asked not to be involved. Well, that's too damn bad. Abusive and harassing does apply. But not from Mr. Stengel. Rather, Miss Siliski is abusing and harassing those listed, by wrongfully involving them in abusing her own children. Miss Siliski further abuses and harasses them all, by leaving everyone's emails in the open. Fact, done, so others think, they all agree. Look how many people all agree with Miss Siliski. But do not give out Miss Siliski's secure email address. This was even sent to Mr. Stengel's attorney. Due to this email, Miss Siliski was forced to make yet another false allegation, stating Mr. Stengel hacked into her computer and added his attorney to her contacts. Really? Apparently, Mr. Stengel also hacked into Miss Siliski's email while she was drafting this, and added his attorney's name to this very email as well. Psychosis has no boundaries or reality attached. However, it also went to her own attorney, Bradford G.Y. Carney, who is witnessing and encouraging the violations of court orders and the ongoing abuses of all those listed and of anyone in their paths. Mr. Carney is also witnessing the driving while papering and papering while driving an entire fleet of buses loaded with victims. You will even notice Sherelle Flowers, Boys Latin School counselor, a main target of theirs from day one. Almost forgot, there were 2 other witnesses to this violation of the consent order, and the driving while papering, and papering while driving. Who are they? Correct? Mr. Liam W. Berg, and Dr. Catherine Killeen. Go team, go!
He is just papering to death.
Class, surely by now, you must be thinking, there is more, there is always more. So, let's go right into a couple examples. Note, yet, Miss Siliski sent Mr. Stengel an email just 13 minutes prior, but didn't include any of the hoodwinked, conned, and played like fools gang. This also went to Mr. Carney. Here is that email header. From Susie S. @gmail.com. Sent Saturday, April the 9th, 2011, 8:52 a.m. To Mr. Stengel. Basketball@stingles.com. CC, Brad G. Carney. Note, as seen, Miss Sileski continued sending Mr. Stengel emails, now from another account, which she had for years. Therefore, how could the email sent in contempt make any sense whatsoever? From Susie Sileski, susiestengel@me.com. Sent Monday, May the 2nd, 2011, 9:46 p.m. To Mr. Stengel.
He is the driving force behind this litigation.
And Mr. Stengel should do this.
Number 16, ordered that neither party, nor Justice Judith ENSOR, shall disparage the other parent, in the presence of the minor children, nor shall they con 300 plus other parties to do so.
He is the driving force behind this litigation. The number of emails that people had to review, he is just papering them down.
In memory of this lady, go on, show them just one more. You have thousands. And all of these are not even included in those numbers. Right. Those are just the transcripts, and not all of them either, and just a few of the filings. I am willing to bet, the number is closer to, if not more than 6,000. I think they are still looking for their first one. Show us one more.
Looking at the spread, the fraud sheets bills. Page number 23 of 130. April the 9th, 2011, was a Saturday. Therefore, when Mr. Carney came to the office on Monday, April the 11th, 2011, noted as covert number 1, we focus on number 1 and number 4. Mr. Carney's bill notes.
April 11th, 2011, read emails from Susie regarding 1. Holding Mark in contempt, 2. Playoff schedule for disabled coach, 3. Multi-page email regarding Mark's conversation with Alex, 4. Closing email account.
Note, billed 0.40 hours, for $150. Fact, besides the multiple emails. Holding Mark in contempt. Really? Exactly what Miss Sileski was doing, in that very email. As this further confirms, redirect focus, then, attack. And, allegations equals confessions. And noted as number 4, closing email account. We know which email that refers to. You will notice, neither Mr. Berg, or Dr. Killeen's column, therefore bills, reflect them receiving this contempt email. Apparently discussed, as they are both missing at entry. Class. We should not pass up this other glaring trait, these research subjects all have. Multi-page email regarding Alex's conversation with his father. That's called paranoid. As Alex always reported, she followed him around while he was on the phone. And we know, without looking, who Dr. Killeen swore that trait belonged to.
He is the driving force behind this litigation.
While we are on that, spread the fraud sheets page, we have. 2 months after they should have ended this fraud circus, apparently, Mr. Berg, in obvious covert actions, also gets his meat hooks into Rabbi Fink, as Mr. Berg's column does not note himself knowingly abusing a rabbi. However, Dr. Killeen's bill notes.
April 11th, 2011, meeting with Mr. Berg, follow-up to Mr. Berg's interview with Dr. Lake, Rabbi Fink, correspondence with Dr. Varon. 0.50 hour for $125.
Really, Mr. Berg, a Jew, himself. However, without a conscience, the Jewish part becomes a very useful tool. Dr. Killeen is attacking the schools, as the independent experts are collectively abusing all in their paths. This while sharing those exciting moments. Apparently, the emails at the top were not what Dr. Killeen was looking for. Then after a 3-hour conversation with Mr. Berg, well, what's a crime ring psychologist to do? Oh my. Oh my.
Gotta find dirt. Gotta find dirt.
He is the driving force behind this litigation.
And Mr. Stengel should do this.
Number 16, ordered that neither party, nor Justice Judith ENSOR, shall disparage the other parent, in the presence of the minor children, nor shall they steal the identities of others to do so.
Besides.
As a consequence of your review of those bills, do you have an opinion within a reasonable degree of professional legal certainty as to whether or not they are fair, reasonable, and necessary?
I believe they were fair, reasonable, and necessary. I believe they were fair, reasonable, and necessary.
Then surely, Mr. Stephen Feder, you have accounts of your own, over the 30-plus years, that would reflect the same reasonableness, correct? How about just a couple? Do you have just one, where you let a client go without being paid, similar to the one you are swearing to, is fair and reasonable? Besides, how does the word necessary apply when a client is not paying you? Are you saying it is necessary to work without being paid? Which tells us their collusion, conspiracy, frauds, and abuses were done with foreknowledge and malice to their countless victims, and not only well documented inside their own bills, but outside as well. As Ms. Susan Silisky rides shotgun during all of this, conning, abusing, manipulating, and constantly violating as many as possible, for as long as possible, including her own children, who have been alienated from reality and therefore being held prisoners for years now, while illegally removing Mr. Stengel's First Amendment rights to inform their victims. He continued documenting the realities of all their frauds, such as this.
I mean, I've got more collusion documented in their own bills, collusion in their own bills, that they want me to pay for. They want me to pay for them colluding against me and my kids. Really?
Mr. Stengel, I've already ruled on the bills. All of these issues have been litigated. The only one who's keeping any of this alive is you keep regurgitating it by posting things and bringing it all up again. This would be over and done but for your own actions.
No, but for their criminal
The
fraud.
only reason...
I mean, I've got more collusion documented in their own bills, collusion in their own bills, that they want me to pay for. They want me to pay for them colluding against me and my kids. Really?
Mr. Stengel, I've already ruled on the bills. All of these issues have been litigated. The only one who's keeping any of this alive is you keep regurgitating it by posting things and bringing it all up again. This would be over and done but for your own actions.
No, but for their criminal
The
fraud.
only reason...
So far, we have the following documented unconscionables: Ms. Susan Silisky, Bradford G.Y. Carney, Silisky attorney; Leon W. Berg, best interest attorney, not; Dr. Catherine Killeen, psychologist; Robert Wayne Lazaro, the mole; Judge this Judith C. ENSOR, corrupt; Judge this Kathleen G. Cox, corrupt; Commission on Judicial Disabilities, who considers these actions judicial decisions, therefore may be errors in decisions. Really, who is next? We come back to this one sample invoice, the first line of Mr. Berg's bill notes.
April 12, 2012, Appeal de novo, Protective Order Hearing. 2.00 hours, for $600.
A bit of history. Mr. Stengel files his first complaint to the Attorney Grievance Commission of Maryland. This complaint includes a 7-inch high stack of crimes, abuses and knowingly false statements, along with evidence such as obstructing justice, encouraging child abuse, abuse to schools, teachers, the police, etc. Complete with evidence backing up each allegation. Evidence such as videos taken in the home, transcripts, Alexa's audio journals, Mr. Berg's countless false allegations, and evidence. Mr. Berg had received this evidence. This relates to the level of deceit possessed by Mr. Berg, as well as the Attorney Grievance Commission. On July 22, 2013, Mr. Berg responds to the Commission with 50 pages of yet more lies, now to the Commission itself, which the Commission states they take lies, quote, very seriously, end quote. The Commission responds to Mr. Stengel, stating they reviewed everything, and they see no problems. Mr. Stengel responds to the Commission, with many of Mr. Berg's lies to the Commission, who says they take lies very seriously. One of those lies just so happens to be in the same invoice being used in this presentation. Next is Mr. Stengel's response to the Commission, regarding just one of Mr. Berg's lies, in his response to the Commission. Noted as Exhibit Number 1.
Exhibit B. Number 1, Prelude. This is a page from a transcript of the hearing on April 12, 2012. I do not have the transcript. The subject of the hearing was Mr. Stengel's appeal from a protective order entered in the district court against him and in favor of Ms. Silisky, his wife. I did not take part in the hearing.
However, that is clearly false, as Mr. Berg's bill reflects that very appeal on April 12, 2012. Besides the fact, Mr. Berg showed up, simply to sit behind Mr. Carney and Miss Silisky, in support, but to really forward their fraud. Also during Mr. Stengel's testimony, Mr. Berg continually made faces to the judge, that of a school child, then left, in the middle of the trial, as his task was completed. He also told Mr. Lazaro, when asked what was he doing there, stated he is not billing for it. This too was false. Either way, Mr. Leon W. Berg flat out lied to the Commission. Mr. Stengel provided the Commission with dozens of these. When Mr. Stengel called the Commission with yet more collusion in their bills, was told, those cases are closed. Not only never investigated, but unvestigated and closed. This includes the crimes by Mr. Carney and others reported. Therefore, the Oversight Commission knowingly authorizes criminals to continue victimizing children, schools, teachers, judges, families, and whoever they damn well please, including the unsuspecting public. But only their friends. Furthermore, Mr. Berg's response speaks of the protective order trial in favor of Ms. Silisky. However, in order to falsely disparage Mr. Stengel, intentionally left out that was Ms. Silisky's second fraudulent protective order filing, and the trial that ensued is known as the altered evidence trial, which Mr. Berg was well aware of. Mr. Berg did not show up at that trial to represent his minor clients, yet showed up at the appeal to manipulate the already deluded Judge Martin and further secure their frauds upon the courts. Mr. Berg also failed to mention, during that very April the 12th, 2012, appeal trial, Ms. Silisky confessed she, in cooperation with Bradford G.Y. Carney, altered the key evidence, which gave rise to the appeal trial. The altered evidence trial is also where Ms. Silisky and Mr. Carney conned Alison Meister Friedman to commit perjury multiple times. It should be noted, both the Circuit Court of Baltimore County and the Attorney Grievance Commission of Maryland removed their photos from their websites. It appears Mr. Stengel's work required changes. Changes such that they do not want their faces attached to their names, therefore their work. Not exactly a sign of pride in their own work. However, they have no problem with the many victims being victimized by their work. No worries, Mr. Stengel has all of their photos and names, and in multiple locations. And their legacies secured for their children, grandchildren, and the many generations to come. It should also be noted, Mr. Berg did not stop by that appeal trial just to con any judge. Hell no. After their colluded efforts of hoodwinking Judge Martin on December the 1st, 2011, they convinced him to hear this appeal trial. Mr. Berg stopped by to make sure their cement still had the grips of Judge Martin's entire being. Anyone want to guess how he ruled in that case? Even after Miss Silisky confessed to altering the evidence, which gave rise to that appeal trial. What you are witnessing, and Mr. Stengel has been documenting, is pure evil. Besides Mr. Stengel providing the evidence of the altered evidence to Mr. Berg on November the 29th, 2011, just 2 days later, on December the 1st, 2011, at the end of the custody scam trial, Mr. Berg stood next to Mr. Carney when Mr. Carney confessed to that, and much more.
That would be fine with me. I'll let Mr. Stengel talk about whatever he wants to vis-a-vis the protective order, and your client can do that.
Okay, great. So the protective order, the piece that Mr. Carney is leaving out, is that there is a document, the document that she claimed was put her in fear, but it was actually altered.
Like everything else, sir. Like everything else. Like everything else. Like everything else. Like everything else. Like everything else.
We now add Attorney Grievance Commission of Maryland. Well, we continue with Judge Judith ENSOR.
Because as Mr. Fetter said, to ferret out the lie, you've got to do more work. And the more work I did, the more frustrating it became because I just kept coming up empty. I just kept coming up empty. I just kept coming up empty.
West's Annotated Code of Maryland. Criminal Law. Title 8. Fraud and Related Crimes. Subtitle 6. Counterfeiting and Related Crimes. 8-609, Counterfeiting of Orders for Money or Goods. Order for money or goods defined. A. In this section, order for money or goods means any writing, ordering, or requesting for the payment of money or the delivery of goods. Prohibited. B. A person may not 1. With intent to defraud another, cause or procure to be counterfeited, or willingly aid or assist in counterfeiting an order, for money or goods. 2. With intent to defraud another, issue, publish, or pass a counterfeit order for money or goods, if the person knows it was counterfeited. Or, 3. Knowingly and fraudulently obtain money or goods, by means of a counterfeit order for money or goods. Penalty. C. A person who violates this section is guilty of a felony, and on conviction is subject to imprisonment for not less than 2 years, and not exceeding 10 years.
If we were to look up on that confession page, we would hear what else Mr. Carney and Judge Judith ENSOR were also well aware of.
As the court pointed out earlier, it's a whole lot more expensive to lie than it is to tell the truth. Because as Mr. Fetter said, to ferret out the lie, you've got to do more work. And the more work I did, the more frustrating it became because I just kept coming up empty.
Of course, for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. I only have the...
Therefore, it's more profitable to lie, because with the truth, backed by evidence, the buck stops there. Besides it being the very reason they never mentioned the actual content of what Mr. Stengel provided, Mr. Carney has a reputation to uphold. However, when Miss Silisky or Mr. Carney lies, they are guaranteed a response, which creates another response, and so on, and so on. Add to that, the crime ring plays toss, across. Then add to that, Mr. Berg sends duplicates to Dr. Killeen. It's a fraud circus. It wouldn't be fair if we didn't take special notice of just some of her delusion, just in one of her statements.
Part of that review, frankly, was with an eye to determining who was actually driving the litigation. And of course, for that, I only have the pleadings filed and the descriptions delineated in the bills themselves. For that, I only have the pleadings filed and the descriptions delineated in the bills themselves.
Really? Only? Judge Judith ENSOR only has the insane number of fraudulent sworn filings, sworn orders, sworn motions, sworn testimony, and the descriptions in their very own fraud bills. To make all of their actions even more ridiculous, all mentioned contradict each other, and often there are contradictions within the same filing, or motion, or even the same transcript page. What would be to a 5-year-old evidence of their crimes, to this villain, is evidence of facts and law. Evidence, mind you, which cannot be questioned. Evidence where the author himself confessed to constantly coming up empty. Having spent loads of time investigating nonsense, it would appear Mr. Carney was ongoingly confused, since he kept investigating. Obviously, Mr. Carney kept coming up empty. That's what happens when you fish in a dry cement pond. Mr. Carney and the others can clearly see the pond is empty and dry. Yet Mr. Carney kept fishing. Mr. Carney kept fishing for years. Someone should tell Mr. Carney the pond will first require some water. One who will Mr. Carney say was directing him? Miss Silisky? The one Judge Judith ENSOR herself said was a liar, and files multiple false financial statements, repeatedly to the same judge. 2. Mr. Carney confessing he kept coming up empty, would mean he has no evidence. 3. Mr. Carney confessed to constantly coming up empty, means his line items are for naught. 4. If Mr. Carney's line items are for naught, how would Judge Judith ENSOR, 10 months after Mr. Carney's confession, use those very line items as evidence of fact? 5. How would Judge Judith ENSOR find that the opposing counsel's confessed to repeated wasted efforts be Mr. Stengel's doing? 6. How would Judge Judith ENSOR find that the opposing counsel's confessed to repeated wasted efforts be Mr. Stengel's responsibility? 7. If Mr. Carney spent so much time, yet kept coming up empty, how would that be necessary, in any way? 8. How many wasteful investigations is needed, before the billing becomes unreasonable? 9. Wouldn't doing work, yet not getting paid, yet continue to do work, and continue not getting paid, yet continue doing work, be the unreasonable, the sworn expert, Mr. Stephen Feder and Judge Judith ENSOR, should be speaking about? Note, this numbering can go on for quite some time. At the very least, we have Judge Judith ENSOR confessing to using the descriptions in their bills as her chosen evidence in this case. At the same time, ignored all the confirmed documented collusion, even confessed to evidence regarding those very bills. Judge Judith ENSOR not only ignored the bank statements, she even ignored her own statements and her own outrage regarding 4 false financial statements, and confessing Miss Silisky, in so many words, is a serial perjurer. Judge Judith ENSOR fraudulently slams Mr. Stengel with judgments in favor of Dr. Catherine Killeen for $13,856, that is on top of the over $20,000, an insane amount already paid by Mr. Stengel, in favor of Mr. Leon W. Berg for $25,676, that is on top of the over $20,000, an insane amount already paid by Mr. Stengel, and multiple judgments in favor of Miss Silisky in the amounts of $636, $1,067, $3,565, for complete bullshit, and the infamous legal bills judgment in the amount of $135,000. Miss Silisky's judgments are in her name. Therefore, Miss Silisky owes Mr. Bradford G. Y. Carney and the law firm Royston, Mueller, McLean and Reed, LLP, in excess of $200,000. Yet Mr. Carney and Company have no judgment for any of that $200,000. How much has Miss Silisky paid towards her $65,000 portion and towards the $135,000 which she is responsible for to Mr. Carney and the firm? How many communications have there been since, in regards to them requesting money from Miss Silisky?
West's Annotated Code of Maryland. Criminal Law. Title 3. Other Crimes Against the Person. Subtitle 7. Extortion and Other Threats. Extortion by Written Threat. Scope of Section. A. 1. This section applies to any writing, whether or not the writing is signed, or if the writing is signed, whether or not it is signed with a fictitious name or any other mark or designation. 2. This section does not apply to a good faith reasonable notice of dishonor and warning of criminal prosecution under Title 8, Subtitle 1 of this article given by a holder of an instrument to the maker of the instrument. Prohibited. B. A person, with the intent to unlawfully extort money, property, or anything of value from another, may not knowingly send or deliver, or make for the purpose of being sent or delivered and part with the possession of, a writing threatening to, 1. Accuse any person of a crime or of anything that, if true, would bring the person into contempt or disrepute. Or, 2. Cause physical injury to a person, 2. Inflict emotional distress on a person, 3. Cause economic damage to a person. Or, 4. Cause damage to the property of a person. Penalty. C. A person who violates this section is guilty of a felony, and on conviction is subject to imprisonment not exceeding 10 years, or a fine not exceeding $10,000 or both. Go to Disc 8, Part 2 of 2.